Welcome to Team Tiggio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
Okay, good morning. We are on the record in the 53rd Circuit Court for the County of Sheboygan, and we are providing public access on our general civil docket, both in the courtroom and also online. And we have a trial scheduled today in the matter of Great Lakes General Contractor, DBA ServPro, v. Deborah Wiley and Krista Wiley. Counsel, you want to place your appearances on the record, beginning with plaintiffs?
Good morning, Judge. Paul Slough on behalf of the plaintiff, Great Lakes General Contractor, ServPro, Gilbert.
Good morning, Your Honor. Courtney Cadot, Legal Services of Northern Michigan, on behalf of the defendants, Deborah and Krista Wiley.
Okay, good morning. And so we're here for the bench trial. I did receive the trial briefs and proposed findings of fact, conclusions of law from both parties. Thank you very much. Those were very helpful. Mr. Slough, do you have any opening statement you wish to make?
I do, just very briefly, but before that, there's just a couple housekeeping matters, if it's all right with the court. I'm going to use the clerk's kindly provided numbered exhibit stickers, so that addresses the first thing that I was going to address. But the second thing was I have a deposition transcript that I'm going to offer to the court. It's the deposition taken de Benies of Brittany Vavalides, who is the insurance adjuster for Farm Bureau. The issue is that I do not have the sealed transcript yet from the court reporter. I just received the digital copy of it yesterday, so I'm going to submit, with the court's approval, the unofficial transcript for your review, and then file the sealed transcript at a later date if that's agreeable.
Mr. Cadot, any objection to that?
I do not.
Okay, yeah, that would be fine. And would we mark that as an exhibit then?
We certainly can. I will do that now, just so I don't forget to do it later.
Sure,
if that's agreeable with everyone.
If you haven't already used up your stickers, if you want to mark that one as plaintiff's one.
If I can approach, I'll just give that to the court now.
All right, thank you.
Do you want this to the court?
Oh, I'm sure.
All right, one is received.
That's all I have. Yeah.
Okay, and any opening statement you wish to make?
Yeah, just very briefly, this is a very straightforward case from a factual perspective, Judge. I'm going to save a lot of my argument on the legal issues until closing. But factually, the Wileys contracted with ServPro to provide certain remediation services due to a water loss, flooding of the basement. ServPro provided those services as agreed to their satisfaction, to the satisfaction of their insurer, Farm Bureau Insurance. You're going to read that in the deposition transcript I just submitted. The construction lien act exists to ensure that contractors get paid. We did the work to their satisfaction. There was a remaining balance, which was the amount of the deductible on their policy that wasn't paid by Farm Bureau. And we substantially complied with the Construction Lien Act. The testimony will establish that. The only strict requirement under the act, based on the case law, is that the lien has to be filed within 90 days after the last material or labor is supplied to the project. And again, the testimony will establish that a service was provided within that 90-day period, and so the lien was timely. In conclusion, we're going to ask the court to enter a judgment in favor of ServPro against both defendants and permit us to foreclose the construction. Thank you very much.
Okay, would you be open to any questions for me at this point?
Absolutely.
Just so, as I read through the briefs, I thought, well, maybe there were some factual questions about the liability of Deborah Wiley, which would have prevented a summary disposition. But a lot of this seems like the facts weren't really in dispute about the services provided. And so it seems to me some of the key issues today are going to be, you said you contracted with the Wileys, but that seems to me one of the principal issues today. Krista Wiley doesn't dispute that she owes this money by virtue of a contract. It seems that there's a dispute whether Deborah Wiley's liable for this debt, but principally whether the services provided constitute an improvement such that construction lien was appropriate. And just looking at the statutory language of that, the services that were provided don't sound to me like they seem very construction-y.
Yeah, they certainly were not services that required someone to be a licensed builder to provide. However, I think when you hear the testimony from the ServPro representatives, you'll better understand that these are very specialized services. This is not just something that someone can go down into the basement with a mop and perform. It requires personal protection equipment. It requires specialized equipment in order for the insurance company to approve it. They apply an antimicrobial type solution to the basement to ensure that it's safe. So this, without question, was an improvement to the home. And again, I think the testimony today will establish that. I don't think that there's much of a question about that. The language in the statute becomes the question, and it's more of a legal question about how does the act define improvement. And that language is very broad. It's not exclusive language, it's inclusive language. So in other words, the examples that the act give are just examples. And some of the examples that are given are very close to what ServPro performed. Things like clearing, altering, repairing, installing, or fixing material or a fixture. And again, specialized equipment was used. This increased the value of the home. This improved the condition of the home. It's within the scope of what the Construction Lien Act contemplates. So that's the first question the court had. The second question, taking them in reverse order, the agency relationship between Krista Wiley and Deborah Wiley. That's what we're going to rely on today. I think the testimony is going to make clear that Krista Wiley was acting as an agent for Deborah Wiley. I think you'll see that both in the testimony from the ServPro representatives, as well as the testimony from the Farm Bureau adjuster.
Okay. So beyond a landlord-tenant relationship, or a lessor-lessee relationship, you're saying that there was an agency relationship. So this isn't just a lien against a lessee.
Correct. That's absolutely correct. Because their relationship was much closer than just a lessee-lessor. This was a mother-daughter relationship, and the daughter was acting on behalf of her mother to assist her mother and acting with a parent authority on behalf of a principal.
Okay. All right. Thank you very much. Mr. Cadet, opening statement.
Yes, thank you, Your Honor. So we believe that the evidence and testimony will show much different results than the plaintiff believes, Your Honor. We believe that the evidence will show that ServPro didn't comply with the construction lien statute in the instances where it possibly could have complied. It definitely wasn't substantial compliance. It was minimal compliance at best. For example, as the court has discussed with plaintiff's counsel already, we believe that the evidence will show that there was no improvement. There was no contract with the owner. There was no lien filed within 90 days of work being completed. There was no service of lien attempted within 15 days. We also believe that not only will the testimony show no compliance, but will also show that ServPro's foreclosure lien and foreclosure lien action was vexatious for being so contrary or so not up to the standards of the construction liens requirements to have no arguable merit. As to there was an additional count aside from the foreclosure of the lien and so forth raised by the plaintiff to sue on the breach of the contract. The evidence regarding the contract will show that only Krista signed the contract. The interest rate in the contract is usurious. And bringing action against Deborah when only Krista signed the contract is not an agency type situation. But it's frivolous. It has no arguable merit. There's nothing in the contract that says that Krista signed on behalf of Deborah.
What would be the remedy if, let's say that we're talking only about the breach of contract claim, if the court agreed with you that it was not a time price differential, but it was delinquency interest and the 1.5% that they're asserting is usurious, what would be the remedy?
So the remedy under the interest rate statute, Your Honor, is that no interest can be charged. So it would be a straight judgment against Krista for only $2,500.
So what about if their contract says either 1.5% per month or the greatest amount allowed by law, whichever is less.
The court would
Is
have
that
have its discretion as far as which portion of the contract to enforce in that regard. But I would urge the court not to, because the plaintiff has only ever tried to enforce the 1.5% per month interest. And even after bringing it to the plaintiff's attention, there was no change in tact or amended filings or anything like that to request that this court or order a 5 or a 7% interest rate, Your Honor.
Okay, thank you.
As to the, there was an additional account raised by the plaintiff and not brought up an argument, but there was an account stated, and those would be similar grounds. There would only potentially be an account stated against Krista, and similarly to the contract charge, the interest rate would also be usurious, and so only at best a $2,500 judgment against Krista for an account stated. As far as our counterclaims, we raised issues. We requested that the court strip or void the lien that's been placed as a result of the violations of the Construction Lien Act and no proper procedure followed, and no, just under the definitions laid out in the Construction Lien Act not applying to this case. We believe that the testimony will justify removal of that lien. And then we also raised a counterclaim as under the Michigan Consumer Protection Act. And we believe that the evidence will show that ServPro caused the probability of confusion and misunderstanding as to the Wiley's legal rights by charging the usurious interest. It caused the probability of confusion and misunderstanding as to the terms of credit, also by charging usurious interest. They charged grossly excess price by charging usurious interest. They evidence will also show that ServPro got Krista to sign a contract with usurious interest rates without getting a clear waiver, or even attempting to get a waiver of her rights under the Interest Rates Act. The evidence will also show that ServPro failed to inform the Wileys that ServPro continued to work on the basement long after ceasing work and sending a final bill to Krista, thus misleading or deceiving them as to the end date of the work. The evidence will also show that recording the construction lien caused confusion and misunderstanding as to their legal rights, as to particularly Deborah's legal rights, given that she had never entered into a contract with ServPro. And so at the end of the day, both the Interest Rate Act violations as well as the Consumer Protection Act violation is entitled the defendants to reasonable attorney's fees. Consumer Protection Act also to actual damages, in which case $2,500 are the obvious actual damages, or the court could choose to charge $250 per violation if the court finds the violations after the close of the evidence.
Okay, thank you, Mr. All right, Mr. Slough, your first witness.
Thank you. Call Joshua Bailey.
Okay, Mr. Bailey, you want to come up and stand here and raise your right hand for me? Do you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Be seated.
Good morning. Would you state your full name and spell your last name for the record?
Joshua Blake Bailey.
Spell your last name.
It's B-A-I-L-E-Y.
All right. Josh, where are you currently employed?
ServPro of Gaylord, Sheboygan.
And what's your role at ServPro?
As of about 2 years ago, I became an owner.
And you said about 2 years you've held that position.
Yep.
Can you describe to the court what it is that ServPro does? Just generally.
We are a restoration company, so we do water, fire, mold cleanup, any kind of cleaning, duct cleanings, carpet cleanings. So when it comes to water, so if someone has a water damage, pipe break, fridge line break, we come in, remediate the water, extract the water, set drying equipment if we need to, and spray antimicrobial to prevent any other further mold growth. And then, yeah, it's pretty much the gist of it.
Is ServPro a licensed general contractor in the state of Michigan?
Yes, they are.
And do you happen to know the license number for ServPro?
I do not offhand.
Okay. If you saw that number, would you recognize it?
I would.
Because there's some document you could look at to refresh your recollection about the license number. Do you want to get that document or direct me to it?
Yes, if you could. Yes.
Which do you have it with you?
I do not have.
Well, I'll tell you, what I have is the license number is L295633. Does that sound like the license number?
Yes.
For Servpro? Okay. I understand that you were contracted to do some work at 5570 Quarry Road in Afton, Michigan.
Yes, that is correct.
You familiar with that job?
Yes, I am.
Okay, how is it that you're familiar with it?
I was one of the first ones on site to meet my crew there when Krista first called us up.
Okay, and what was your role in that project?
Just to kind of oversee. So I was acting as the project manager at that time. So that pretty much states that I am in touch with Krista, kind of letting her know what's going on, the process, and in communication with the insurance company, letting them know what's going on, what we are finding, just kind of updates.
Okay. Tell me a little bit about that first meeting you had at the property.
Yep. So it's been a minute, so I'll try and remember as much as possible. But when we first got on site, I do remember there wasn't any power on. I can't remember if they shut the power off due to the mechanicals down in the crawl space, basement, whatever we want to call it. And so we had to bring in we have a trailer, our generator mounted trailer or trailer mounted generator to run all of our equipment. So we had to bring that in. I met with Krista on site. We kind of walked through, kind of told her what we do and how we were going to do it. And then shortly later, my crew showed up and we began the work.
Okay. Did you speak to anyone else on that day other than Krista Wiley?
I did not.
Okay. And is Krista Wiley seated here today at
Yes.
the defense table? Did you ever speak with Deborah Wiley at any point during this project?
I did not. No.
Did you ever see Deborah Wiley at the home at any point?
I did.
Okay. What needed to be done as part of this project?
So I believe it was some kind of submersible pump that had either failed or had gone out. So water had filled into the basement crawl space. So we needed to extract. There was some like rotten debris down there, wood that we needed to get out. So first off, we went in, extracted, got all the water out. I believe we had to set a submersible pump to get the kind of the water down. And then once we get it down to about 1 inch, we can start extracting with our trucks that has an extraction machine on it. So we took the water down as far as we could, pulled out all the debris, all that kind of stuff, sprayed antimicrobial to prevent any kind of mold growth or anything like that. And then we would set our drying equipment.
Okay. And since we're talking about this now, does that type of work require any special certification or licensure?
It does, yes. So in this type of scenario, we had to dress up in PPE suits, so Tyvek suits, gloves, rubber boots, and we were wearing half-face respirators as well.
Okay, and I appreciate that answer. My question was really, do you get any type of certification or training to do that kind of work?
We do, yes. So we have a company come in every year to test fit all of our employees for the masks. We walk through with them as far as how to properly get into the PPE, fitment, gloves, boots, all that kind of stuff.
Okay. Do you know what that certification or licensing is called? Is there a name for it?
I do not. I don't think there's a specific name for it. We just have a guy in Gaylord that is certified in it, and yeah, I don't know if there's a specific name.
Okay. So let's go back to your conversation with Krista Wiley at your first visit to the property. Did she ever indicate to you that someone else needed to approve the proposed work?
Never once.
Okay. Did it? How did it appear to you in terms of who was responsible for getting this work done?
Krista. When I first met her there, we were talking about some animals that she had there, and it never occurred to me that someone else owned the property. She acted like it was hers, and it never once crossed my mind.
Okay. You mentioned some animals there. What kind of animals were at the property?
Just typical like farm animals, dogs. I think there was maybe some goats. Yeah, just your typical farm animals.
Okay. And did it appear to you that Krista Wiley was residing in that home?
Yes.
Okay. Do you now know that Krista Wiley is not the legal title owner of that property?
I do. Yes.
Okay. All right. I'm going to show you what we've marked as Exhibit 2. Or like a copy of the exhibits as we go? Or?
Not as we go.
Okay.
I'll just keep, once it's admitted, then I'll receive the routine.
Okay, so I can approach it.
Yes.
Okay, actually, I took these out of order. I apologize. I marked the wrong one. I'll show you what I marked as proposed Exhibit 3. Do this one first. Taking a look at proposed Exhibit 3, Josh, you recognize that document?
I do. Yes.
Okay, what is that document?
It is our authorization to perform services and direction of payment, meaning our authorization, we get these signed before we start any kind of work on the property. That authorizes us to start the work, and the direction of payment means we work a lot with insurance companies one-on-one, so we can bill the insurance company directly and they can pay us directly.
Okay, and is this a standard contract? Or?
It is. Yep, we use this on every single job.
All right. How many pages is this document?
It is 2 pages.
Okay, is this a true and accurate copy of? Well, let me ask this first. I see Krista Wiley's name on this document. Was this something you presented to Krista Wiley on the day in question?
Yes.
Okay. And did you see her sign this document?
I did. Yes.
Okay. And is this a true and accurate copy of that document?
Yes, it is.
Okay. I'll offer Exhibit 3 evidence.
Any objection?
No objection.
3 is admitted.
Okay, so let's turn back to Exhibit 2, the proposed Exhibit 2. Do you recognize that document?
I do. Yep. This is the estimate that I had written.
Okay, so that's something that you prepared?
Yes.
And I mean, tell me, what do you mean by an estimate?
So we work with the insurance companies on this software called Xactimate. It's in a software that we write all of our estimates in to get to a number for our services. So simply plugging in line items for the work that we have performed, and it pretty much spits out a price for us. And yeah. So it's an estimate writing software.
And is this the estimate that was prepared for Krista Wiley with regard to 5578 Quarry Road?
Yes.
Okay, now before I offer this, I see on some of the later pages, these are dated April 24, 2024. Is this updated as the project progresses?
Yep. So we take, when we first get on site, we take what we call pre-photos. We go in, take photos of what the pre-loss condition looks like, just for insurance wise, so we can prove to them like, yes, they had water or they had some type of damage. And then throughout the process, as we're drying, we do take photos as well to show progress moving along, or if we set a new specific piece of equipment, we take a photo of that. Insurance companies are super picky as far as us charging for certain equipment, like a heater per se. So we do have to take a photo of it to show them that we did in fact place it.
Okay, got it. I'll offer, this proposed Exhibit 2, a true and accurate copy of the proposal as last amended.
Yes.
Okay, I'll offer a plaintiff's Exhibit number 2.
Any objection?
No, thank you, Your Honor.
2 is admitted.
Thank you. Was a copy of Exhibit 2, whether as last amended or some earlier draft of it, ever provided to Krista Wiley?
Yes. Yep.
Okay. Was that something that you sent to her?
Yep. Via email, I believe.
show you what's marked as Plaintiff's Exhibit number 4. Can I approach Judge?
Yes.
I was asking Tom. Do you recognize that document, Josh?
I do, yes.
Okay, and what is that document?
It is a screenshot off of my phone on my email showing Krista that you can see the PDF attached there. That is the copy of this estimate. Just letting her know that we are sitting around 3,700.
Okay, yeah, and before you get into
Yep,
what the document says, what's the date of this document?
April 24th, 2024.
Okay, this is a true and accurate copy of that email.
Yes.
All right, I'll offer Plaintiff's Exhibit 4.
Any objection?
No, thank you, Hunter.
4 is admitted.
Thank you. Now, you were about to say, Josh, what were you trying to communicate to Krista with this email?
That we are currently at $3,700 as we sit. And I said, I attached the estimate for you so you can look it over. I sent it to Brittany, who is the Farm Bureau adjuster. If we have any, letting her know that if our equipment does go through the end of the week, we're going to be sitting around $4,500 to $5,000.
Okay, $5,000.
Yes.
All right. And it was fair to say this was still just a proposal.
Yes. Yep. I'm just giving her some kind of roundabout number to let her know.
Okay. At any point during this project, did Krista Wiley object or complain about the work being done by CertPro?
Never once.
Okay. Did she express any opinion about the work being done?
Yes, she did. She told us that she had no complaints and that we were doing a wonderful job, and never once heard that we did anything bad or anything outside of the guidelines.
Did the work that was being done require a residential builder's license?
I did not. No.
Okay. And why is that?
We were not building or replacing anything. We were just simply there to extract water, remove any kind of debris, set drying equipment, and dry the materials in the foundation.
Okay, so didn't require any structural modifications to the home. That's fair. All right,
Fair.
but did require some specialized equipment and processes in order for the Farm Bureau of Insurance to pay. Is that true?
Yep, it's very true.
Okay, you already talked about the specialized equipment. I'll have you just take a look at Exhibit 2. There's some photographs in there.
Yep.
Do you want to just maybe walk through those photographs? They're numbered starting on page 8.
Yep.
And just point out the equipment that's being used in each of those photographs.
You want me to just go through like each photo kind of thing?
Yeah, if you can just
Okay.
identify the photographs by number
Yep.
and then what equipment's being depicted.
So on page 8, that is a picture of one of our air movers, aka a fan, down in the crawl space basement. And then let's see. So next picture, on page number 9, there are 2 more air movers and a dehumidifier. So a dehumidifier is obviously it helps take out the humidity in the air, creates a better drying zone. And yeah. Page number 10, some more air movers. Page 11, 4 more air movers. Page number 12 is a hose from our extraction truck. Like I said earlier, we have extraction machines built into our vehicles that extract water. So that is a part of the hose where we extract water. Okay. Page 13, it appears that looks like the sump pump or some type of pump. I believe this was the cause of loss. So when we go into houses, we have to take a picture of said cause of loss for insurance purposes.
So that was a pump that was already on site.
Yes. Yep. That was a pump that was already set on site. We did not set that.
So some sort of sump pump or something.
Yep. Yep. Correct.
What about page 14?
Actually, you know what, Paul? That's that actually looks like one of our pumps.
Oh, okay.
I apologize. Like I said before, we did end up having to set a pump. Now that I look at it better, it is one of our pumps. So we did. That's another tool that we use. Our truck mounts cannot suck a ton of water, so we bring in a submersible pump to get the water down to a certain level. Like I said, about an inch. And then once that occurs, we bring in our other extraction tools.
Okay, and then what about page 14?
Page 14 is a picture of the front of the house.
Okay, page 15?
Page 15 is, it looks like a pre-photo. So this would have been taken before we had done any work. You can see the water level was pretty high in there, reaching up to the hot water heater and what looks like the furnace. Page 16 is pretty much a similar thing, showing the water level. You can see the floating debris, all that kind of stuff. Page 17 is another pre-mitigation of showing more materials that are floating, water down the crawl space. Same with page 18, another pre-mitigation photo. Like I said, we have to take as many photos as we possibly can to prove to the insurance that there is water down there, and that, in fact, that it does need to be pumped out.
Page 19 appears to be a
Yep, it's just a
diagram.
sketch of the basement crawl space.
What about page 20?
Page 20 is a picture of what looks like a dehumidifier, a fan, and partial of our Firebird. So at the time, there was not any power on. So in order for us to dry materials properly, we have to have a set temperature, which is right around about 65 degrees. So if it's cold down there, our dehumidifiers won't run properly. They'll just shut off. So we would have to stick in a heater, electric heater, to heat the space properly for our equipment to dry properly.
And this was on what date?
This was on April 23rd, 2024.
Okay, so not the warmest weather.
Not the warmest weather, no. Yeah. Getting there, but not.
Next page.
Next page is that Firebird. You can see the extension cords. So we had, at the time, we were still running our portable generator on site. So we had to run extension cords down into the crawl space, running to the heater. Yeah, that's just simply the heater down in the crawl space.
Okay, and why don't you just look through the remaining, I think there's maybe 3 or 4 photos. Is there anything else we should talk about in there? That we haven't
No,
already
just page 22 is more extension cords, power cables. The little box that you see kind of in the left corner there is what we call a power box. We can run a 220 cable off of our generator into this power box, and we can run more extension cables off of that. That way we're not running cables back and forth to the yard. There's just one cable that runs to the yard. Page 23 is another picture of our hose for extracting. Page 24 is a picture of our sump pump that we stuck down there to get the water down to, like I said, about an inch of water. And the last page is just another sketch.
Thanks, Judge. I'm going to show you what's marked as plaintiff's exhibit number 5.
Okay.
Can I approach, Judge?
Yes.
You recognize that document, Josh?
I do, yep.
What is that document?
This document is our, what we call our drawing report.
Okay, and is this drawing report specific to a job?
Yes, it is.
And what job is that?
The Wiley job, Deborah Wiley.
Okay, and is this a true and accurate copy of the drawing report for Deborah Wiley, Crystal Wiley's project?
Yes, yes, it is.
Okay, I'll offer exhibit 5.
The objection,
No, thanks, Your Honor.
5 is submitted.
Okay. So what is this drawing log indicating, Josh?
So we have a software that we plug all of our equipment in, take these photos that you saw in the estimates. It pretty much tells us how long equipment's been there. We go off of drawing records. So as far as when we go back to the job and do equipment checks, we can stick in material readings, and it just shows the insurance that, yes, these materials are improving, we're drying, and it's showing that our drying equipment is actually working. This second page is just a page of, it simply shows how much equipment we set, how long we set it for, and the amount of hours that it ran for.
Okay, very good. Now I see that, well, let me ask you this first. Is this document submitted to the insurance company?
Yes. Yep.
Okay. I see that the last date of service on page 5 indicates April 30th. Looks like some photos were taken.
Yes. Yep.
Or uploaded or something like that. Is that fair?
That is fair.
Okay. Was that the last date that work was performed on this project?
It was not.
Okay. And so why is it that Exhibit 5 would only show through April 30th?
At that time, we had picked up all of our drying equipment down in the crawl space. So that meaning we removed all the equipment out of here. So this report would have ended on that day.
Okay. And so am I correct in saying that the equipment related to drying was removed on April 30th?
Correct. Yes.
Okay.
Yep.
And so then therefore the drying report wouldn't have
Yes.
dates after that?
Yep.
Okay. So what services, if any, did ServPro provide to the Wileys after April 30th of 2024?
We had set a heater inside the house because the furnace was, I believe, like I said, it's been a little bit, but I believe the furnace was still not running at the time. I was speaking with Krista at the time, and she had animals inside the house, and we had talked about putting a heater inside the house to keep the house at a minimal temperature for the animals. So that piece was set after we left.
Okay. Was that just like an electric heater?
Yep, it was another electric heater, a little bit bigger than the one down the crawl space, but same concept as far as running. We had to run it off the generator and all that.
I mean, what's the capacity of this electric heater? And this isn't like a little bathroom heater.
No,
right?
it's big. It's about 4 feet tall, and it could heat probably a 1,600 square foot house.
Were the Wileys charged by ServPro for providing that heater?
They were not. They were only charged for the small heater down in the crawl space to the insurance.
Okay. And was Farm Bureau Insurance involved at all in providing that additional heat to the home after April 30th?
I do not believe so, no.
Okay. And so what was the timeline in terms of providing that heat to the home?
Like I said, it's been a minute, but I believe it was if it wasn't within a day, I would say within a couple of days. Chris and I were texting back and forth with the whole situation, and it was simply more to help her out in the scenario because I believe we were fighting with the insurance going back and forth as far as getting the furnace replaced, the pump replaced, and all that. So it's simply just to help her out.
Okay. And you say a couple days, you mean a couple days that what did you mean by that exactly?
As far as setting the heater inside the house, I can't remember how long it was since when we took all the equipment out of the crawl space until when we set the heater inside the house.
Oh, I see what you're saying.
Okay. Yeah, it could be a week. It could be, I'm not sure.
Okay. Well, I'm going to show you what's marked as plaintiff's proposed Exhibit 6.
Yes.
Josh, you recognize that document?
I do. This
Okay, what is that
a report that we pull. This is a program that our employees clock into. So they clock in, clock out of every single job. This is how we keep track of their hours on every single job. It's simply just a report showing their hours, their time, and what job they were on.
Okay. And what is Exhibit 6 specifically? Is it related to a specific job?
Yes, it is. It is related to the Wiley job.
All right. And is this true and accurate copy of the time entries in ServPro software for that job?
Yes, it is.
Okay, I'll offer Plaintiff's Exhibit 6.
Any objection?
No, thank you, Your Honor.
6 is admitted.
What is the last time entry on Exhibit 6?
May 30th, 2024.
Okay, and what service was provided on that date?
That day we were picking up our Firebird heater, electric heater inside the house.
Okay. Had you had communications with anyone about coordinating a pickup of that heating unit?
I did, yes.
Okay, tell me about those conversations. Who were they with?
They were with Krista directly, whether it was between phone calls or text messages, just letting her know when we can pick it up. Just kind of working around her schedule as far as when she can meet us on site. There were some days that she wasn't able to meet us on site, so we were just kind of working around her schedule to get it.
All right. And was there some sort of issue when you picked up the unit and something was left behind or something?
Yeah, there was a thermostat. So these heaters, you can hook up a thermostat to set a certain temperature, 70, 80 degrees. So there was a thermostat that was left behind. Our guys are notorious for leaving it behind because it's just a smaller unit. Yeah, there was an item left behind.
Okay, and was that before or after May 30th?
That was after.
Okay. And just to be clear, this house didn't have any heat other than that unit that you left behind for that period in May.
Correct.
Did you leave that unit behind just to extend the time in which you could file a construction lien on this home?
No.
Okay. Was there even any dispute in early May of 2024 about payment or non-payment?
No.
Okay. So it's fair to say then the last day of providing service to the home was May 30 of 2024.
I object, Your Honor, calling for the witness to make an argument or a legal conclusion from the testimony.
Yeah, I think that calls for the manner of that question would call for a legal conclusion that would be sustained. And he did testify factually about the time.
Thank you. Josh, were there any subcontractors involved?
There was not.
All right. I'm going to show you what I'm marking as plaintiff's exhibit, proposed exhibit number 7.
Yes.
Josh, you recognize that document?
I do.
Okay, and what is this document?
It is a sworn statement.
Is this your signature on page 2?
Yes, it is.
I'll offer plaintiff's exhibit number 7.
Any objection?
No, Your Honor.
7 submitted.
Okay. Josh, I think you already said this, but there were no subcontractors involved in this job working under ServPro?
Correct.
And is that what exhibit number 7 essentially indicates?
Yes, it is.
Okay. Josh, I don't have any other questions for you. I think Mr. Tiggio will have a few now. Thank you.
Maybe hand me those 7 exhibits, please. Or 6 exhibits. Mr. Cadet, cross examine.
So just a couple of clarifying questions, Mr. Bailey. Good morning. So you had testified that you were one of the first ones on the scene on April 20th. Is that right? Who was there before you?
I believe Chris was there.
No, as far as someone from ServPro, if you were one of the first ones to arrive.
It would have been my technicians, so water technicians.
And who were they?
They were, I believe, Shelby, and I cannot remember the second one that was on site.
Shelby and somebody else. So in your standard practice, do the initial technicians on site ask the customers for signatures on the contract?
Yes.
All right.
Yep.
So in this case, you testified earlier that it was you that saw Chris to sign the contract, right?
Yes. Yep.
So what caused the variation in the standard practice as opposed to the first technicians arriving on the site having her sign it, but instead you did?
I was there when she was signing it. So our technicians have an iPad that we do all of our programming off of, that we run the software off of. And so I was there when they signed it with my technicians.
And so who inputted the data, the name and address into the contract?
It automatically gets submitted in through Farm Bureau. So we get an assignment sent through, and it gets put into our system, and it automatically puts in the name.
Can I see that? Mr. Bailey, I'm going to approach you with proposed exhibit A. Do you recognize that?
I do. It is the thermostat to the Firebird electric heater.
Your Honor, I move for the admission of proposed Exhibit A as Exhibit A.
Any objection?
I don't have an objection.
A is admitted.
Is that the device, Mr. Bailey, that was left behind after May 30th?
Yes.
All right. I don't have any other further questions for this witness, Your Honor.
No.
Redirect?
No redirect. Thank you very much.
Okay. Thank you, Mr. Bailey.
Thank you.
All right, Mr. Slaw.
Yeah, plaintiffs will call Tanya Beardsley.
Tanya, what's her name?
Beardsley, I'm sorry.
Ms. Beardsley, would you please raise your right hand for me? You solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God. Will you please sit?
Good morning, Tanya. We state your full name and spell your last name.
Tanya Renee Beardsley, Beardslee.
Okay, and where are you currently employed?
Sure,
And what's your position at ServPro?
I'm the accounts receivable administrator.
And how long have you been in that position?
7 years.
Are you familiar with the books and records of ServPro?
Yes,
And are you familiar with its file with regard to its work at 5578 Quarry Road in Afton?
yes,
All right, and did ServPro issue an invoice to someone for the work at that address?
yes.
Okay, and who was it directed to?
Crystal Wiley.
Okay, I'm going to show you what's marked as proposed Exhibit 8. I can approach.
Yes.
Do you recognize that document,
Yes, I
Tanya?
do.
And what is that document?
It's one of our invoices.
I'm sorry. I'm sorry.
What is it?
It's one of our invoices for services rendered.
Okay, and specifically, was that invoice for a particular project?
That is for Crystal Wiley project, 5578 Quarry Road.
Okay, and what's the date of that invoice?
Oh, it was dated 5/2/2024.
Okay,
I'm sorry, what was that date? I didn't hear.
5/2/2024.
Okay.
okay, and I see that there are some other dates on this invoice. Was this invoice updated over time?
But the system automatically adds monthly a late fee based on the balance it's due. And this one was due June 1st of 2024. And then after that, it'll start calculating interest.
Okay, and so what was the last date that interest was calculated on this invoice? And I'm just trying to establish what the date this invoice was printed
We
was.
stopped running interest on November 7th of 2024.
Okay, all right, so I'll offer plaintiff's exhibit number 8.
Any objection?
No, thank you, Your Honor.
8 is admitted.
Okay, so what's the total amount of this invoice?
The total, you want the grand total, like what's due right now?
Well, why don't you explain the totals on this?
Total is $68,2063. That's $6,820.63.
Okay.
The insurance paid their portion of $4,087.03.
Okay.
Which leaves a balance of $2,733.60.
All right. First question, why is it the insurance company, if you know, paid less than the full balance?
Because they paid their portion, the Wileys have a $2,500 deductible.
Okay, so there was a $2,500 remaining amount
Correct.
that was the Wiley's responsibility.
Correct.
All right. Now, the interest, what sort of finance charges or interest are charged on this invoice?
1.5% monthly based on the balance that's due.
Okay, and is that something that's spelled out in the contract that we marked as Exhibit 2?
Yes, I believe so. I'm not exactly sure. I'd have to read it.
Okay. Yeah,
I
you're
know it
welcome.
says it on all our invoices.
Okay. Did Farm Bureau approve the work that was done by ServPro?
That I know of, yes.
All right. And in your experience, would an insurer pay if a job was not completed to their satisfaction?
Correct. Generally, after the insurance pays their portion, they pay their deductible.
No, I'm sorry, you
Sorry.
misunderstood my question. Will an insurer pay on an invoice if they're not happy with the work
No.
that was done?
No,
Okay.
that's not been my experience.
Okay. So did Deborah and/or Krista Wiley pay for the remaining balance on this invoice?
No.
Okay, and do you know why that is?
I'm not sure,
Okay.
because it's a deductible. It's just a standard industry procedure.
As a result of their non-payment on this, does ServPro incur some sort of cost?
Well, we have to start the process of trying to get a hold of them, calling the insurance company, starting all the paperwork of just calling monthly.
Is ServPro in the business of lending money?
No,
Okay, so if someone doesn't pay, does that impact abilities to pay wages, fixed costs, things like that?
we're having to cover it.
Okay, so costs ServPro money when
Yes,
accounts go delinquent?
yes.
Okay, and is that your understanding of the reason for the 1.5% finance charge? When did you start charging the finance charge?
It would have been June 7th it started.
Okay, and when did ServPro stop charging it, if at all?
We stopped in November.
Right, so there was no finance charges charged after November 7th of 2024.
No.
Is that fair?
Mhm.
Yes, yes.
Yes, sorry, correct.
Sorry. Okay. What else did ServPro do as a result of non-payment?
We did try to set up a payment plan. And that was done in December, and that's why we stopped the fees. Because we were hoping to enter a payment plan with her.
And did that happen or no? I'm going to show you what's marked as plaintiff's exhibit number 9.
Yes.
Time, what's that document?
It's a claim of lien.
And specifically, was this related to a project?
It is for Krista Weiler project.
Okay. And is this something that's contained in the books and records of ServPro on this file?
Yes,
Okay. Are you familiar with this document?
I am.
Okay. Is it a true and accurate copy of the claim of lien that was filed by ServPro?
It is. I did not file this one, but yes, it is. Yes.
Okay. But you're familiar with this document?
Yes.
All right. I'll offer plaintiff's exhibit 9.
Any objection?
No, thank you, Your Honor.
9 submitted.
Okay. What's the last day that labor and material was supplied as noted in exhibit 9?
May 30th,
Okay. And what's the date that exhibit 9 was recorded with the Register of Deeds?
August 5th
And what year?
of 2024.
Okay, so the last day of providing labor and material was May 30, 2024, and it was recorded August 5th of 2024. Was May 30th, excuse me, was it recorded within 90 days of May 30, 2024?
Yes.
Okay. I'm going to show you now, it's marked as plaintiff's proposed exhibit 10. I can approach.
Yes.
Do you recognize this document, Tanya?
Yes.
What is this document?
This is what was sent to the county when we applied for the lien.
Okay, take a closer look at this. Make sure that we can look through all the pages. What's the date on this document?
September 3rd.
Okay, and it appears to be what on the first page?
It's a letter to recommending or asking for certified mail receipt of the lien sent to the homeowner and a lien request.
Who's it addressed to?
Deborah J. Wiley,
Okay. And again, this was dated what?
September 3rd.
Of 2024. Okay. Is this a true and accurate copy of a document in ServPro's file regarding the job for 5578 Quarry Road?
Yes.
Okay. I'll offer plaintiff's exhibit number 10.
Any objection?
No, thank you, Your Honor.
10 submitted.
Okay. So it appears in exhibit 10, Tanya, that there was some effort to send a copy of the recorded lien to Deborah Wiley. Is that
Correct.
fair? Okay. And I see on the last page of Exhibit 10, there's a certified mail envelope.
Correct.
Okay. And it's marked return to sender. Is that your understanding?
Correct.
Okay. Did you ever have conversations with Krista or Deborah Wiley?
About this?
Yeah, about the lien at all?
No.
Okay. All right. I see that there's a LN on the envelope. Do you know what that stands for?
I do not. I'm not sure.
Okay. Is it maybe left notice?
I assume left notice.
Okay. And it looks like there's 3 dates on there.
Correct.
All right. In any event, there was some attempt to send a copy of the lien to Mrs. Wiley. Do you know what date ServPro received the lien back from the Register of Deeds?
I do not.
Okay. Do you know what the turnaround time is for mailing it out to getting it back from
It
the Register?
varies on each county. Some take longer, some take shorter. We can never get a guaranteed date.
Okay. One of the allegations in this case is that ServPro failed to send a copy of this by certified mail within 15 days of recording the lien. Again, you don't know when they would have gotten, ServPro would have gotten the lien back from the Register,
No.
correct?
Correct.
Okay. But what is the standard practice at ServPro?
When we get it back, we send it back that same day. We
Okay.
send it to the homeowner the same day.
Okay. Has ServPro incurred any attorney fees as a result of this case?
Yes,
Does the contract that's marked as Plaintiff's Exhibit 2, does that permit ServPro to recover attorney fees and court
Yes.
costs?
I
Yep.
believe so.
Okay. And any idea how much has been incurred at this point?
I do not know at this point.
All right, those are all my questions. Thank you very much.
Mr. Cadet, prosecuting.
Thank you, Your Honor. Ms. Beardsley. Isn't it true that you never billed Deborah Wiley?
We've never billed her. We sent her invoices. I believe we emailed them as well.
So I'll bring your attention to what's already been entered as Exhibit A. Was this bill sent to Deborah Wiley?
It was sent to Krista Wiley. That's what our job, that's how the job was in our system is.
All right. Do you have any bills that were sent to Deborah Wiley?
No. Because Krista Wiley was our job name.
No, you had mentioned some negotiations regarding a payment plan, right?
Correct.
And did you prepare a proposed payment agreement
Yes.
with a monthly credit card payment agreement? Here, I'll bring the court's attention to proposed Exhibit B. May I approach the witness, Your Honor?
Yes.
Ms. Beardsley, I'm presenting you with what's been marked as proposed Exhibit B. And do you recognize that document?
I do.
Is that the payment agreement that you prepared with credit card payment agreement on the second page?
Yes.
And does that document appear to have been altered or changed in any way since you prepared it?
No.
Your Honor, I move for the admission of proposed Exhibit B as Exhibit B.
Any objection?
I'll object on the grounds of relevancy, Judge. I think he's laid a foundation and authenticated the exhibit, but I don't understand the relevancy of it. And it is actually a settlement negotiation under MRE 408.
Your response, Mr. Cadet?
So the relevancy plainly is to show vexatiousness, Your Honor, vexatiousness, Your Honor. Insofar as that document, once admitted, will show the court that what they called a $100 payment agreement was actually a $200 a month payment agreement. As far as the objection regarding settlement negotiations, the rule of evidence that applies to settlement negotiations is not all encompassing. The only prohibited evidence from settlement negotiations, Your Honor, is the to prove the amount of the claim or the liability. This document is not being entered for that purpose. The document is being entered in order to show the unfair dealing and vexatiousness of the plaintiff.
Just taking a quick peek at your counterclaim. I mean, this was referenced in the trial brief, so I know the ambiguity you're talking about, that it says she'll pay $100 a month, but then on the what it would charge the credit card, it'd be $100 twice a month. Is that fact part of your, hang on, I'm not asking you a question, I'm talking to the lawyer. Is that fact part of your counterclaim for violation of Consumer Protection Act?
I don't believe off the top of my head that it's part of our counterclaim, but it is mentioned in, I believe, our answer and affirmative defenses, Your Honor, whereas wherein we stated that Krista Wiley attempted to negotiate.
Right, but how would that make a fact more or less probable? The facts at issue in this case about whether they performed the services, whether they were paid for the services, whether these defendants are liable for those services, and whether this is a valid lien.
Those facts, this does not shed light on, Your Honor.
So what fact does it tend to prove?
The statutory right of my client to claim that the plaintiff is acting vexatiously.
Because they filed a claim when the customer failed to agree to a payment plan?
That is correct. But not only failed to agree to a payment plan, failed to agree to a payment plan that was other than what the plaintiff represented within the payment plan document itself.
I mean, I understand what you're getting at, but I think the probative value of that is fairly limited, and I do think it falls within the purview of the court rule that would generally exclude offers to settle. That would have been an offer to settle that didn't really fall through. So I'll sustain the objection.
All right. So, Ms. Beardsley, do you recall responding to written interrogatories and requests for production of documents?
I'm sorry, I didn't understand that.
Do you recall responding to written interrogatories and requests for production of documents?
No.
So I have proposed exhibit C. I'll approach and present you with that document. If you flip to the last page, I'll ask you if you recognize having signed that document.
Yes.
And so now that you've recognized your own signature, do you recognize having?
Yes, I'm sorry. There was many pages of paperwork that I didn't recall this.
All right. So taking a look at all the pages of this document, does anything appear to have been altered or changed since the date that you signed this document?
Does not appear.
Your Honor, I move for proposed exhibit C's entry.
Any objection?
Yeah, I have to object to hearsay, Judge. I may be being a little overly technical. They are out-of-court statements being offered for the truth of the matter asserted. Typically what counsel would do is ask her the questions
And then impeach her.
and then impeach her with the statements, right? I think that's really the proper procedure.
Yeah, I think that would be, to actually admit the discovery responses for the truth of the matters asserted therein would be an out-of-court statement by this witness, so I'd sustain that objection.
Your Honor, I know that you sustained the objection, but would I have a chance to respond anyway, or for the
Oh,
record?
sure. I mean, why wouldn't that be hearsay to admit the discovery?
Because it's a statement by a party opponent being offered by the adverse party. It's not hearsay.
But it's just an employee of she said she works in accounts receivable. It's an employee of the party. Does that make her a party opponent?
Yes, it does, Your Honor.
Mr. Slough, what about the party opponent exception? I guess she is an agent.
Yeah, she is an agent of ServPro, and she signed these as an agent of ServPro. There's no question about that. Again, again, in my experience, typically they would impeach them by asking the same questions the witnesses they're live.
Well, that's true, but Mr. Cadet's entitled to proceed how he wants to proceed.
Yeah, that's true. And I'll withdraw the objection. I mean, I could look up the court rule, and I think we could
All
probably
right,
argue
and
about
thank you, Mr. Cadet, for reminding me not to answer a matter before it is heard. So the objection is overruled and C is submitted.
All right, thank you, Your Honor. So if you could, on Exhibit C, Ms. Beardsley, these pages aren't numbered, but it would be the 4th page, where at the top it says request for production of documents. And to the question that was asked in this document, number 1, produce all invoices and or billing statements sent to defendants. Isn't it true that you responded, see enclosed letter dated September 3rd, 2024 with attachments, as well as proposed $100 a month payment agreement that was sent on December 11th, 2024 and refused?
Correct.
Was the payment agreement that you sent on December 11th, 2024 actually for $100 a month?
the same objection, Judge, to relevancy and settlement.
Yeah, isn't that getting into the matter that I already said?
It is, and I'm attacking it from a different direction to give the court an opportunity to reconsider its plain error in calling a proposed payment agreement evidence of settlement negotiations. That's banned under the court rule.
Sustained.
Bringing your attention to, again, Exhibit 8, Ms. Beardsley. You testified that this document was sent to Krista Wiley or you testified that it was dated May 2nd, 2024?
Correct.
So what date would this document have been sent to Krista Wiley?
Our date doesn't change in our system. It stays the original date and the original due date. And then monthly it gets sent out or emailed with the monthly interest that's added each month.
So you sent this out monthly?
Correct.
So on May 2nd?
Actually, probably would have been June 2nd or June 7th. Sorry, that's when the interest loads. And I believe that's when it goes out.
No additional questions, Your Honor.
Any redirect?
Couple quick questions, Judge. If I turn your attention to Tanya's exhibit 10.
Oh.
There was a question earlier by Mr. Kadad about whether or not there was ever an invoice directed to Deborah Wiley. The first page of exhibit 10, I think you said this earlier, but who is this letter addressed to?
That is addressed to Deborah Wiley.
All right, and the second page of that, what is that document?
It's the invoice.
Okay, so a copy of the invoice was directed to Deborah Wiley in September of 2024.
Correct.
Okay. And again, this last page indicates that a notice was left on 3 dates
Correct.
and no one picked it up from that
No.
address.
Correct. It was returned.
Those are all my questions. Thank you.
Can you recross on those points?
No, thank you, Your Honor.
So, Mr. Kadat, if you could approach and receive B and C back.
Yes, Your Honor.
Okay, you can start. Thank you.
Plaintiff will call Deborah Wiley.
Ms. Wiley, would you please raise your right hand for me? Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You can see it.
Good morning, Deborah.
Good morning.
Is it all right if I call you Deborah today?
Sure.
Okay, I just wanted the confusion between Krista and Deborah, so, all right. Are you the owner of the home at 5578 Quarry Road in Afton, Michigan?
Yes.
Okay. What's the relationship of Krista Wiley to you?
She's my daughter.
All right, does she live with you at that address?
Yes.
Okay. And what's the arrangement with her living there?
There's no arrangement. She and the 2 kids just live with me.
Okay. Does she pay for any of the expenses of the home or pay you a rent for living there?
Doesn't pay rent, but she pays for some of the bills.
Were you aware of the basement flooding situation that's been testified about today in this
Yes.
case? Okay. And how was it you became aware of that?
My daughter told me she went downstairs and there was a foot of water.
Okay. Okay. And did you know that ServPro was going to come and help take care of that situation?
She said she contacted the insurance company and ServPro.
Okay. And you agreed with that procedure?
Sure, because what else? It had to be done.
Yeah. And did you see ServPro at the home working on getting it cleaned up?
I work at Walmart, so I don't see a lot of them there at all.
Did you ever see ServPro's equipment at the home?
Oh, yes, when I come home.
Okay. Did you ever question, hey, how is ServPro getting paid, or why are they here doing this work?
No.
Did you ever talk with anyone at Farm Bureau Insurance?
No.
How was it that an insurance claim got done?
They're my daughter.
Okay, so you were having your daughter assist you with do that insurance claim?
Yes.
Okay, and you had your daughter assisting you with getting ServPro to take care of the water in the
Yes.
basement? That's yes? And Krista had your permission to arrange for that work?
Yes.
So she was acting on your behalf?
Yes.
Were you dissatisfied with any of the work that was done in the basement?
I never went down in the basement to see what it looked like.
Okay, so I mean, it's fair to say you weren't dissatisfied with it then?
No.
No, it's not fair, or no, you weren't dissatisfied?
Either way.
Okay, so you weren't dissatisfied, correct?
Correct.
Okay. And you agree that work was necessary?
Yes.
And you agree that it certainly improved the condition of the basement?
I never.
I object, Your Honor. Again, this is argumentative, calling for the witness to make a legal conclusion.
Sustained.
You agree the water in the basement had to get cleaned up?
Well, of course.
And why is that?
Well, would you like to have a foot of water in your basement that knocked out your furnace and your water heater and everything?
Yeah. So didn't have hot water with that water in the basement?
No,
And the heat was out as well?
yes.
Okay. All right, those are all my questions. Thank you.
Any cross?
No, I don't need to cross-examine Deborah Wiley, Your Honor.
Okay. Ms. Wiley, thank you. You can sit down there. Mr. Stock?
Yeah, I'll call Crystal Wiley, please.
Okay. Ms. Wiley, please raise your right hand for me. Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you can see it.
Good morning. Is it all right if I call you Krista?
Yes,
All right, thank you, Krista. You've heard the testimony here this morning.
correct.
I'm going to have you look at what was marked as plaintiff's exhibit number 2. Do you have that in front of you?
I do.
Oh, I'm sorry. Sorry, actually,
Yes, that's fine.
I got it. It's exhibit number 3.
Oh, no problem. Here you go.
Do you recognize that agreement?
Yes,
Okay, is that an agreement that you signed?
correct.
All right. And that was to contract ServPro to perform services at 5578 Quarry Road.
Correct.
Okay. Now, you don't own that home, is that correct?
Correct.
Okay, your mother owns that home?
Correct.
You live at the address
Yes.
with her? Okay. And do you have any type of power of attorney for your mother or anything like that?
I do not.
Okay. Do you assist her typically with financial transactions?
No.
Okay. But you heard her testimony about the fact that you were the one
I guess
arranging.
describe financial transactions. Like, what do you mean by that?
Well, I'm just asking generally, do you assist her with things like filing insurance claims?
I would contact insurance.
On her behalf, though?
I would, well, they know that I'm the daughter of her, so like we've had Farm Bureau for 30+ years.
Okay. Other financial transactions you assist her with?
No,
Okay.
I do help pay bills.
You help pay bills for?
Yes,
Okay. What about help her with writing out checks?
I can't write a check to save my life.
Okay. What about arranging for payment of bills?
If I'm the one who set it up, if I contacted like a contractor to come out to do some work, I'll do the arrangements directly with them, yes.
Okay. On behalf of your mother?
No, just on me, because I'm living in the home, so if I need something done,
Okay. All right, but again, it's your mother's home, correct?
correct.
And so is that something you would talk to your mom about, the fact you're having a contractor come out and do work on the home?
Not if I'm paying for it, no.
So you feel you have the authority to arrange for that to be done?
If I feel something needs to be done, yes.
Okay. And your, again, that's authority your mother has given you because she doesn't have an issue with you doing that?
She doesn't really give me authority. I mean, they just do it.
Okay. So let's be specific about this case, I guess. When you contacted ServPro, did your mother ever tell you that, hey, I'm not okay with ServPro?
No,
Okay. And she was aware that ServPro was coming out and doing work?
correct. We've used them in the past.
Okay. And you agree they perform the services in a good workmanlike manner?
To a degree, yes.
All right. What do you mean to a degree?
They left debris behind.
Okay. Did you ever express that to them?
I did bring it up to the 2 girls that initially arrived on the property. They were there when I first called in to ServPro. I did state we have no electricity. You'd have to bring a generator. The 2 girls arrived, did not bring a generator. So then they reached out to Josh Bailey to have him bring it. By that time, I've already signed that contract because Josh even arrived on the scene.
Okay. Do you recall the testimony from Mr. Bailey about some text messages where you indicated that this was great work that you've done? We really appreciate your help.
I assumed yes, I did do that, but I assumed by of them leaving and clearing everything out, that they would have removed the garbage and debris that were left in the basement.
Okay. So that was something later that you discovered.
Correct.
Okay. And turning back to contracting with ServPro, again, your mother never objected to you entering into that contract with ServPro, correct?
Correct.
And she knew they were doing the work,
Yes.
and they were doing the work for the benefit of her home, correct? You would agree that the work they did in the basement improve the condition of the basement.
I object, Your Honor. Again, we're calling, asking the witness to make argument in the form of a legal conclusion.
Well,
I'm not asking her for the legal definition of improve. I'm just asking her generally as a layperson, did it make the basement better?
I mean, I think
I mean,
that's fair as a
suck the
factual
water.
matter. Yeah, go ahead and answer.
It sucked the water out. I mean, the water was gone.
And did that,
Eventually the water would have evaporated or gone away, but yes, it did. They did clear out water.
okay. And you agree that that was something that you asked them to come and do?
Yes, they are a water restoration company.
Okay. And you asked them to come do that because it was necessary to get it done, correct?
Correct.
You agree that ServPro and Farm Bureau too relied on you having the authority to enter into that contract?
Once you, that Farm Bureau, you contacted Serpro, and Serpro essentially just deals with Farm Bureau. I'm no longer in the picture.
Okay, but again, you signed the contract with ServPro, correct?
Correct.
Okay, and you would agree if ServPro was relying on the fact that you had authority to authorize them to come in and
The
make these
two
improvements?
girls that
Let me finish my
arrived-
question. Hold
I'm
on.
sorry.
So you agree that ServPro was relying on your representation that they had authority to come in and work on the home?
I object, Your Honor. This is calling for speculation. She can't know, she can't make a determination through her testimony as to what ServPro relied on. ServPro had an opportunity to testify about that.
Yeah,
I'll rephrase it.
I think that's fair.
I'll rephrase the question. You never told anyone from ServPro that, hey, I can't authorize you to come in there without getting my mom's permission first.
The
correct?
girls just stated I had to be over the age of 18. I didn't have to be the homeowner.
Oh, okay, but you never indicated, hey, wait, I can't sign this. without
I did
getting my
ask
mom's
them
permission.
if I
Hold on,
had
Let me
to-
finish my question. You gotta be patient. I'm sorry. You never indicated to anyone at ServPro, hey, I can't sign this without getting my mom's permission first.
I did
correct?
to the girls. I don't remember their names. There was two girls that showed up. I did state I'm not the homeowner. They said that's fine as long as someone over the age of 18, you could sign it.
Okay, but again, my question is, you never said, I can't sign this without.
I
first
just
talking
said
to my
that. I
mom."
said I'm not the homeowner. They stated to me, as long as you're over the age of 18, you can sign it.
Okay, but again, you didn't refuse to sign it before talking to your mom, correct?
She already knew Serbo was on the way.
All right. And you didn't ask ServPro to get your mom's signature on it?
They
correct?
stated I didn't have to be the
I
homeowner.
understand that, but you
I don't think
didn't,
you understand that.
but you didn't tell them, hey, I want my mom to sign this.
I
You went
think
ahead and
that's
signed it.
asking the answer.
Okay.
And I know what her answer is, and you don't like that answer.
You heard the testimony about the heater being left at the house after April 30th of 2024,
Correct.
and that was true, right?
Not to my
The heater left-
knowledge, they cleared out stuff on 426 from the basement. They did put a Firebird upstairs. We were in a hotel from 420 to 430. So the 26, everything was cleared out in the basement, which would have been like the drying equipment, that kind of stuff. So then from 426 to 430, they did put a Firebird upstairs. Once we called consumers felt safe enough because the water was extracted. Everything was gone, that they were able to come in and turn on electricity. So we
Okay.
could run our own fire.
All right, so your testimony then, let me make sure I understand, is that that Firebird was not there after 4:30 of 2024?
As far as I'm aware, yes.
Okay, do you remember a text message about them coming to pick up the heater on May
I
16th?
do not have any of my text messages because prior case, that phone was confiscated. I got a new phone. That phone kind of crashed out. So all my messages from me and Josh Bailey, I do not have record of.
Okay, that wasn't really my question. My question is, do you recall?
I don't recall
For-
anything because I don't have, it was a year ago.
Okay, so is it possible then that that Firebird heater was in fact in the home after April 30th of 2024?
It could be possible that they refused to pick it up. Yes. Was it being used? No.
So what was the reason of leaving the Firebird heater then if it wasn't being used?
I object, Your Honor. It also calls for speculation.
Well, I guess implied in that is only if you know.
I don't know why they left it.
Was the heat on in the home?
We had electric fireplaces that we plugged in.
Okay, was that sufficient to keep the home completely heated?
Yes,
If
because
you
we're
know.
going into May. So
Okay,
yes.
so again, you don't know why they would leave a Firebird heater
The
then?
guy just refused to pick it up. I don't know.
Okay. And, just a moment. This is good. Can I approach the witness?
Yes.
All right. Chris, I'm going to show you a text message dated April 28th, 2024. You recall, well, I'm going to show it to you. It's kind of rude.
And this is just gonna be impeachment, right? Because we can't admit something like this. Okay.
Anything else or just this? No, it might be. Okay. Some of it's not totally relevant. That's why we're kind of scan through. All right. Thank you. Okay, I'm going to show you that text message, Krista, from April 20th, 2024. Can you read that text message?
Out loud?
Well, read it to yourself, and I'm going to ask you some questions about it.
Okay, yeah,
All right. And so do you recall now having exchanged some text messages with Mr. Bailey?
that's just pertaining to the generator,
Okay,
having
so,
his equipment hooked up to it. I just want to know like what would it increase our electricity bills at that time? That was April 28th. That has nowhere to do with May.
okay, but so you said, curious how much electricity does the heater pull?
Correct, because we would run it into our electricity. That was the 28th. So the 28th, 29th, and the 30th.
Okay.
Of April, not May.
All right, and so that was going to be after they removed their generator, right? Because you were concerned how much it would pull off of your,
They pulled their generator on the 28th.
right? And so you were asking how much electricity does the heater pull?
For 2 days. I'm not gonna run a thing for 30 days.
All right, but the heater was left there after they pulled out that other equipment, correct?
Yes,
And that was because there wasn't heat in the house?
correct.
Okay, so your prior testimony about having electric fireplaces plugged in, clearly you were,
You stated till May 30th. Okay, we're talking April 28th, 29th, and the 30th. You went all the way to May. That's another extra 30 days. So from the April 30th to May 30th, yes, we had electric fireplaces plugged in. It got warm enough towards the end of May. That text message is from April 28th,
when did you have your furnace fixed in the house?
the following year, the February of 2025.
Okay, so there was no furnace in the house, correct?
Well, the
During this
broken
time
one.
period,
No, there was, well, the broken one was in there,
but it wasn't operating?
correct.
Okay. Do you recall, well, if I can approach you, Judge. Maybe just read that text message to yourself.
Okay, yeah, he did a good job. I'm not saying he didn't do a good job. No one's disputing that.
Okay. And do you dispute that that electric heater that was left, that Firebird, was picked up sometime around May 30th of 2024?
I don't recall when it was picked up. It wasn't being used. It was set out. If you enter the house, at the front door, there's a porch area. That's where the Firebird was. It was set, it was stacked in with some other stuff.
Okay,
along
I'm
with-
just sorry to cut you off. I'm just asking you, do you know when it?
I do not.
Okay, those are all my questions. Thank you, Judge.
Any cross?
I don't have cross-examination, Your Honor.
All right, you want to, hand those exhibits back, please? Yeah, you can start them. All right, Mr. Slough?
No other witnesses, Judge. Thank you.
Mr. Cadell?
So, well, I hate to do this to Krista, but, well, can I call Krista Wiley as my witness, Your Honor?
Yes.
Thank you.
All right, Ms. Wiley, I'll just remind you that you remain under the oath I just administered to you, so go ahead and resume your seat.
And so, Krista, you testified to, several of the details as to what happened, but I want to try to slow it down and get a greater level of detail, without bouncing around from issue to issue like you were just now through the plaintiff's direct examination. So, to be clear, do you own any ownership interest in the home on Quarry Road where you live?
No.
And can you describe for us step by step what happened on April 20th, 2024?
It was a Saturday. It was in the morning. I woke up and it was cold. I figured power went out. I'm strange. I had to sleep with the radio on and a fan. Those were still on. So obviously the power did not go out. So I like something with the furnace, maybe go like the pilot. So I get up and I walk down to the basement where we have, it's an older basement. So you have like concrete stairs. I walk down there. There is a switch at the top I turn on, but you can't see into the basement until you go down to the left. There's another light switch. I stepped in water. So as soon as I stepped in water, I backed right out because you have electricity and water don't mix. So then I backed up out of the basement, let my mom know, hey, there's water down here. I contacted Farm Bureau through their emergency phone number and filed a claim. Also let Farm Bureau know that I was contacting ServPro to come out.
And so did you call ServPro after Farm
I
Bureau?
did. I don't remember who I spoke with, though.
Do you remember what ServPro said to you when you called?
I just stated that we have Farm Bureau as an insurance company and that we have water in the basement. I'm assuming there's a busted pipe. I did contact Consumers Energy. They did come out to shut off electricity. I did contact Ellsworth because they're at propane. They did come out to shut off propane, so it'd be safe to enter for ServPro to enter into the basement.
And how soon after calling ServPro did they come?
Well, I'm not sure where they came from. So roughly an hour and a half, two girls showed up in a van of a box van or something like that. They showed up, I met them out front and I directed them to the back. I asked, how you gonna run your equipment because we don't have no electricity. They stated that they would have to contact somebody else. So I don't know if they texted Josh or called him. I think we did call him. And then we had to wait for Josh to arrive on scene. And then Josh arrived in his pickup truck. And then he explained to Josh that, hey, I explained to the initial ServPro people that we have no electricity, no power. You have to run all your equipment off a generator. So then Josh had left the property to go back and retrieve a generator, which they do pull with their pickup truck. It's a decent sized generator, I want to say 6 foot, but around there. They brought it in.
All right. So at what point in this timeline that you just recited did you sign a contract?
With the two girls. Josh was not present.
Did you sign the contract then before Josh arrived?
Correct.
And in what format was the contract presented to you?
It was on a tablet.
On a tablet. Did you have an opportunity to review all of the words in the contract before
No,
signing?
it was very small print.
So the entered exhibit 3, can you take, may I approach it? Or, yeah, all right. So the, just to be clear, did you type in the customer name, address, city, etc.?
No, that was already on the tablet.
And where it says insurance company unknown, did you type that in?
I did not. They were aware it was Farm Bureau.
No. Where it says printed name, towards the bottom of that page 1, did you print your name?
No, I just did a little squiggly line.
Where it has the date, did you enter the date?
No,
Did you do anything on this page 1 except for a squiggle mark at customer signature?
that is it.
On page 2, did you have an opportunity to review page 2?
No, it was like it wasn't really pages. It was like they just scrolled to this when you sign it and then they scrolled it up.
Who scrolled it up?
The girl.
Okay. And at the bottom where it says customer initials, do you believe that's you?
Yes.
Okay. Did anyone discuss with you the terms of the contract before you signed it?
No, she just said I had to sign it as an authorization form for them to start work.
So when did you first review this contract?
Do not, I think when I was served paperwork, like when I was served by Mr. Bird.
Did you get a copy of this contract after you signed it?
I did not.
And so when you signed this tablet, what did you believe that you were signing?
Just a form for them to start work. I didn't know it had anything legal binding or anything like that.
Did you know that the contract said that they could obtain a mechanical lien if prompt payment wasn't made?
No,
Did you know that the contract required you to pay 1.5% monthly interest if prompt payment wasn't
No.
made? What was your first reaction upon learning about that interest rate?
didn't know what it means. Still don't know what it means.
How did it make you feel?
Object to relevancy.
What would be?
Well, the relevance is goes to the Michigan Consumer Protection Act counterclaims, Your Honor, as to the probability of confusion, misunderstanding.
All right, for that purpose, objection overruled. Go ahead.
Thank you, Your Honor. So how did it make you feel, Krista, upon learning about the 1.5% interest rate?
Yeah, I'll object to foundation too, since it's not characterized as an interest rate, it's a finance charge, but.
Well, this witness said she didn't really know what it means. So, I mean, the court will determine the legal. Well, go ahead and answer the question about how you felt when you heard about that charge, whatever.
Confused. I didn't understand it. I don't know. Still don't know what it means.
Did you believe that you were entering into a credit transaction when you signed this contract?
No, they just said it was for them to start work on the house.
So did you, when did you learn that this contract stated that you agreed to pay ServPro's legal fees if they engaged in collection actions?
I think when around December, when I received, I got the construction lien. I think when they served me papers. I don't really remember when.
Okay. So, well, what was your first reaction when you learned about potential liability for these attorney's fees?
Frustrated. disappointed. I don't know.
Do you believe that you should pay these fees?
No,
Why not?
because I agreed to do a payment plan prior to even going into court. I'm not disputing that the deductible's owed.
All right. Did you know that the contract required you to waive a jury trial if you were sued?
I didn't read it.
When did you learn that the contract required that?
I think when we came to court. Was it arraignment? No, not arraignment. Like the first time we come. I think the judge out there stated that it would be like a 1-day bench trial. And then he stated that it wouldn't be a jury.
How did it make you feel to learn that you had no right to a jury trial in this case?
I don't have no answer.
Did you tell ServPro at any time that you signed this contract on behalf of your mother?
No, again, like I stated to the previous attorney, they just stated, I was told I was not the homeowner. They said it didn't matter as long as you're over the age of 18, you could sign it.
When did you learn that ServPro was alleging that you signed on behalf of your mother?
When they filed the construction lien, and it was in her name.
And what was your first reaction when you learned of that allegation that you
I was
signed?
pissed because they didn't do any improvement to the home. There was no construction done. Kind of did my digging into a construction lien, and she had no part in this. This was between me and ServPro.
So now, while the work was being done, did you talk to Tanya Beardsley or anybody else off-site employed by ServPro?
While the work was being done, we weren't home. Like at that time, we had horses, goats. We had a whole farm going on. So we would come home in the morning. We were staying in the hotel in Atlanta. Come home in the morning, let all the dogs inside out, go potty, feed and water everybody. I had to have because we had no water at that time, I had to have a water company come in to deliver water to the home. So we weren't really in contact with the workers. They had access. They didn't essentially come inside the front door, if that makes sense. They drove around the back where we haul in our round bales. So they had access as long as they didn't let the horses out. They were allowed to come in through that gate. The one guy, I don't remember his name, he has a farm, so he was comfortable coming in the gate without the homeowner being present or somebody living in the home present.
So did you personally observe them doing any work?
No, we were not home.
No, at the time that ServPro was there, were there other contractors besides ServPro doing work on the home?
No, it had to be safe enough for other contractors to enter. So they had to get all the water out, get the basin completely dried out. Get ups, I want to say, came out on the 30th to get water start working. They installed a jet pump.
And with Ginnups, for example, did you end up owing them money for that, or was that covered by insurance entirely?
So if we rewind, I think Aubrey said they came out, initially installed the jet pump, didn't install it properly, so then Ginnups came to fix it because he kind of knew what the issue was. It was just a 220 had to be dropped down to 120 volt. So then water got connected. But that was after all the drying equipment was moved out of.
So sorry, Krista, the question was, did insurance cover Ginnup in full, or did you have to pay something?
We had to pay out of pocket. Well, Rich didn't charge me for coming out for that one because he felt bad because the horses, we had to pay for water to be caught in. So he just kind of stopped out. He understood, he knew what the problem was. And he was kind of frustrated with the other plumbers that refused to come out and fix their mistake. So he didn't charge us for that. Ginnups did install our water heater, and insurance cut them a check directly for the water heater. So they were paid in full for the water heater.
So Do you believe that ServPro did the work that they were asked to do?
Correct.
And do you know anything about antimicrobial treatment?
I don't know if there's a smell to it or nothing. I don't even know if they installed it. I don't know if it's pet friendly. I don't even know how they put it in.
When did you first learn that they performed some antimicrobial treatment?
I think when I was reviewing all the documents that you sent to me and it was brought up.
Is the basement still in a dry condition today?
Yes. It is a Michigan basement, so it's like, it's dirt.
All right, that Exhibit A, the thermostat that was entered, the black box. Did you bring that to court today?
I did.
And where was that? Where did you find that?
The same where the Firebird was, right in the front porch area.
Right. Was there any other equipment left behind?
Not that I'm aware of, no.
At any point, do you believe that ServPro cleaned your basement?
They did not remove debris.
So for example, you look at page 15 of Exhibit 2. Go to page 15, Krista.
Yeah, this lumber, they just stacked up against the wall.
All right, what about this red barrel that's in the lower left corner of the photo?
Oh, they just, that is an old pressure tank and they just stood it up against the wall.
All right. So do you know whether they actually did remove any debris?
No, there's still a garbage bag down there with debris in it that they picked up.
Do you know what debris is in that garbage bag?
Insulation, stuff that they removed from. If you go to page 22, there's insulation that blocks that opening that was on, that they put on the ground and then they put in the garbage bag and they just left it.
And where is that garbage bag now?
Still in the basement.
So when did you learn that ServPro came to have performed work on your property until May 30th?
I'm not aware if they were out there till May 30th and they were trespassing.
So did you receive any bills from ServPro?
May 1st, May 2nd.
Did you receive any bills after that?
I did receive monthly invoices via email.
And so what did you do in response to these bills?
Nothing,
Why?
because I didn't have the $2,500 up front to pay it at that time.
Did you offer a payment plan?
Not until December.
What happened when you offered a payment plan?
I reached out to Tanya Beardsley.
I'll object, same objections before, Judge.
And I'll respond in the same way, Judge. She's not offering to show the amount of the claim or the liability, but just to show what actually happened in her attempts in good faith to resolve the issues and the inappropriate response from ServPro.
Well, but sure, but whatever the nature of the debt, if the debtor then makes some offer of payment plan, that doesn't obligate the creditor to not pursue legal remedies, right? So her
right, but
offer
there's
to
a
set
very
up
big
payment
leap
plan,
between those two concepts, Your Honor. So what we're talking about is the offer of a payment plan as an offer of proof of belief that a payment plan was agreed to, and then upon presentation of a written payment plan, that payment plan saying something other than what they agreed to, and then being informed, as a further offer of proof that the written agreement wasn't what they agreed to orally, a refusal by ServPro to then discuss or acknowledge even that the written agreement was different than what was talked about orally.
Right, but they don't have to enter into any agreement for payment plan before pursuing the remedy. So I think I do continue to believe that evidence is inadmissible. Sustained objection.
And I would like to mention, just for a trailing thought on that issue, Your Honor, ServPro did allege that Krista refused to pay. And this testimony is further relevant for Krista's willingness to try to work out an agreement.
All right, my ruling will stand.
I'm sorry?
My ruling will stand.
I understand. And so, Chris, without discussing what the terms of negotiations were, how did the negotiations with ServPro make you feel?
Same objection, Judge. These aren't relevant to the Consumer Protection Act claim.
Yeah, I'm still just, I understand the point you're trying to make. I just disagree that it's relevant to the legal claims here today. So it's just.
So when did you learn that ServPro filed this lawsuit?
After, well, I don't know how to answer that, because you like denied a payment agreement, so like. When I talked to Tanya, we had a payment agreement, I stated what I wanted to state, told her,
Same objection, Judge.
I found out after
Well,
the
hang on.
fact.
It overruled for that purpose. She's just laying a foundation for, and this is a bench trial, so the law would presume, and I would apply that I'm going to disregard stuff that's not just.
So I continue.
You can continue,
Okay.
yes.
So we had this agreement to come up with. She said if we came up with this, she wanted to avoid contacting the attorneys. She wanted to resolve this prior to getting the attorneys involved. And I said, okay, I can afford this amount a month. And she's like, okay. And then when I got this emailed over to me, the third paragraph made absolutely no sense because it stated I would pay $100 a month, but then they withdraw on the 1st and the 15th. In which in turn, I reached out to Josh Bailey because Tanya was difficult to deal with. Josh claimed he was on Christmas vacation. I felt bad for him.
Judge, I'm sorry.
Yeah, I think this is non-responsive and irrelevant, and I'll disregard.
All right, so let's point so as far as the moment that you learned that they sued you in court in Sheboygan County.
When I was served by the officer.
All right. In those papers that you received, was there any sworn statement included in those papers from stating a sworn statement of the nature of certifying that they did work without any subcontractors and no debts were owed other than to them?
Not that I recall.
So why did you decide to fight this lawsuit once you learned that you were being sued?
Because they're trying to foreclose our house.
And so what do you hope to achieve as a resolution to this case?
Just having a payment agreement to pay their deductible that was owed to them. Not to lose a home.
I don't have any other questions for Krista, Your Honor.
Any questions, Judge? Krista, you agree ServPro's entitled to be paid for the work it did.
That was never disputed, no. So I do, I guess I agree.
You testified earlier that you felt ServPro was trespassing when it came back to your home in late May.
They didn't feel they were trespassing, but if they were there up until May 30th, I'm not aware that they've had permission to be there up until May 30th.
All right. I can approach the witness just, Krista, I'm gonna have you read this text message on May 28th of 2024, and then the following message
So can we go back to like May 16th where,
Well, I just want to ask you about those first. Okay.
okay, they obviously refused, they haven't come picked it up and we're talking May 16th. So equipment's not being used. Why is it still there?
Okay, so my question is, on May 28th of 2024, were there text messages exchanged where they indicated they were going to come out Thursday morning and grab the heater?
Which is fine, but it wasn't being used.
So is that a yes?
Yeah, it's right there.
Okay, so, and you indicated that that was fine, correct?
For them to come get their heater, yeah, because they need to get their equipment out of my
Okay,
house.
so they weren't trespassing by coming and getting their
I
heater?
didn't state that they were trespassing. If they didn't have permission and I didn't know they were there, then that would be considered trespassing.
Okay, well, I guess my understanding of your testimony earlier was that they did not have permission to come get the heater. Is that
They had
not the case?
permission to get the heater, but if they were there for other purposes, no, they didn't have permission.
Okay, fair enough. And again, the heater was there as of May 28th, 2024.
It was not being used, and you clearly can say
The
May
answer is a
16th
yes, no question. Yes, the heater was there, correct?
for his text messages, yes.
I'm asking you, do you recall the heater being there on May 28th of 2020?
I don't recall it being there, no.
Do you remember them telling you they were gonna come out and get the heater?
He
on
stated May
28th?
16th, he was gonna come out and get the heater. So
I'm
yeah,
asking you about May 28th. Did they tell you they were gonna come out and get the heater?
clearly that message states that,
And you said that was fine, correct?
correct?
Okay. I'm gonna show you what's admitted as plaintiff's exhibit 4. You have that in front of you already. Mr. Bailey testified that this was an email he sent you in April of 2024. Do you recall receiving that email?
Correct.
Okay, and there's an attachment to this, which Mr. Bailey testified was a proposal they submitted to Farm Bureau. Do you remember reviewing that proposal?
The rough draft,
Correct.
that was, I looked at it, I don't really dig into it, no.
You didn't read the whole thing?
No,
So you don't know whether that proposal would have referenced applying microbial treatment to the basement?
no, this was just because we had issues with Farm Bureau, so we had to have something sent over so that Farm Bureau could start cutting.
But again,
this
you didn't read the attachment, correct?
No, I did not.
All right, so you don't know whether it indicates there would be treatment in the basement?
Correct, I didn't know.
All right. All right, last I want you to look at plaintiff's exhibit number 3. Is that in front of you?
Yes,
Okay. You see the bold text in all caps right down at the bottom center of the page?
correct.
Can you read that for me, please?
I have read this authorization to perform services and direction of payment, including the terms and conditions of service on the next page hereof, and agree to the same.
Okay, and you did in fact sign this agreement?
Yes,
Okay. You indicated in your testimony earlier that you didn't read this agreement.
it was on tablet, so no, and it was obviously way smaller than this.
Okay, did you ask someone to get you a copy so that you could fully review it?
We're in an emergency situation, that's not priority to get a copy of it,
Okay, so the answer is no.
correct?
And did you ask anyone to explain what these terms were that you were agreeing to?
I didn't read it, she just says authorization for them to perform work.
Okay. You could have read it if you had wanted to, correct?
If I want to stand there and hold her tablet for 15 minutes, yes.
Okay. And you
But they
chose,
had to
you
have that
chose
signed so
not
they
to,
can start
correct?
work.
You chose not to, correct?
Because she said just sign it, so I signed it.
Okay, but again, you could have read it if you wanted to. Yes.
I don't know if I could have read it, if she would allow me to sit there and hold her tablet while they start work.
My other question was, did you ask them to explain what these terms were?
No,
I'm gonna have you just read, well, let me just ask it this way. Do you dispute that the contract says that interest and finance charges will be charged at the maximum allowable by law or at 1.5%?
again, I didn't read
per
the
month?
contract.
Okay, but you don't dispute that it says that here?
I don't even, that's a legal question. I don't know how to even, if I would dispute it or not.
I'm
I
just
don't even
asking you
know.
if that's what the text
I don't know
is.
what it means, so,
I'm just asking you if that's what the text is on the page. You don't dispute that that text appears?
well, no, it's right in front of us.
On the second page, paragraph 5, the first sentence, you don't dispute that.
Again, I didn't read this.
I'm just asking you what it says. Ma'am, I'm not asking your legal
To
interpretation.
provide, bring legal action to collect monies due under the contract. Can we read the whole thing?
Read it to yourself, please.
Yeah, I have no idea what this even means.
Okay, do you
So
agree?
mechanical lien to me would be something that you'd work on a vehicle. That's
Okay.
mechanical.
Let's wait for my question, please. So paragraph 5, that first sentence, you don't dispute that it says that the provider can collect reasonable legal fees and costs in an attempt to collect.
I don't know of how I would dispute it or not.
That's,
I don't know
that is
even-
what it says. I'm not asking you to interpret it. I'm just asking what it says.
Well,
It
it
says
says,
that,
yeah, we
yes.
can read it together.
That's a yes.
Yeah, I can read it. I mean, I don't know what it means, but
Okay, how about you just read the last sentence in paragraph 5 for me?
again, I don't know what a mechanics lien is.
Okay, but it does say that you're granting them the right to file a mechanics lien. Correct.
In my theory, mechanics lien would be something with a vehicle.
I'm not asking you what you think it means. I'm just asking you, just, that's what you signed, is that? you're
Yes,
giving
again,
them
I didn't
consent.
read it when I signed it.
All I'm asking you is that that's what it says, correct?
Correct.
Those are all my questions. Thank you.
Can you handle this exception? Can you redirect?
No, thanks, Your Honor.
Okay, you can set them.
May I call Deborah Wiley, please, Your Honor?
Okay. All right, Ms. Wiley, I'll just remind you that you remain under the oath that I previously gave you. So go ahead and have a seat. Go ahead, Mr.
Thank you. So, Deborah, similarly as I did with Krista, I just want to give you some time to move more slowly through the events that occurred regarding ServPro. All right. So, what do you remember about April 20th, 2024?
Not a thing.
Do you remember learning about water in the basement?
When I got up, he said there was water in the basement. We had no heat.
Did you see it for yourself?
No, I did not go. I don't go down those stairs.
Okay.
I would probably fall down.
And so when ServPro came out, were you at home?
I don't recall if I was at home or if I had left and gone to work.
Do you normally work during the day?
Yes, I usually leave the house about noon,
Okay.
and I don't get home till after like 10:30 at night.
So did you ever have any interactions with any of the ServPro?
No,
people?
I did not.
Did you ever get anything in the mail from ServPro?
I hardly ever get my mail because it's always picked up for me by my daughter, so I did not receive anything.
All right. What about email? Do you do email?
No,
Do you do text messages?
no, I don't know. I'm old school. I write.
So now this contract, Exhibit 3, had you ever seen this before?
No, I've never seen any contracts whatsoever.
Would you have, how did you obtain notice of this lawsuit?
When I was served papers?
All right. Did you read through the papers when you were served with them?
No, I did not.
Why not?
Because it's mostly my daughter that had set it all up and that, and I did not go through it.
All right. So at any time, did you learn that this agreement called for a mechanical lien against your home?
I have no idea what a mechanical lien is, and I never knew that there was a lien against the home until it was mentioned to me by my daughter.
And so what was your initial reaction when you learned about that?
I have no idea what the lien means.
All right.
So I had no reaction. I thought, well,
So when did you learn that this contract signed by Krista as Exhibit 3 required a 1.5% monthly charge?
I never ever knew anything about it.
Do you believe that? I'm sorry, strike that. What about that the agreement allowed Krista to pay legal fees if Surf Pro engaged in collection actions? What did you learn about that?
I never heard anything about it. All I know is that my daughter tried to set up a payment plan to pay it back.
So do you believe that any of these terms of the contract apply to you?
I never signed any contract, and so I have no idea what any of it means.
So do you know what work Surf Pro actually did do on your home?
They took the water out.
All right. And did you actually ever see them on your property or in your home?
No. Like I said, most of the time I'm not home.
Did you see any of the equipment that Surf Pro used?
Yes, whatever, the big generator, whatever it was that was left out on our porch.
All right.
And I asked my daughter, I said, why is it still here? And she said, well, they haven't come to pick it up yet. So.
Now, during this whole incident, did you have any contact with your insurance company?
My daughter did all the contact with the insurance company.
Did you have any contact with any of the other contractors, like for the water heater or the jet pump or
No.
anything like that? So since April 20th, 2024, when this incident began, have you been down in the basement at all?
I never go down there. I had no reason to go down there.
Did you receive any bill from Surf Pro?
I never personally saw a bill from them.
When did you learn that Surf Pro had filed a construction lien against your home?
When my daughter told me about it, and I don't remember the date that was.
What was your first reaction about learning of the construction
Well,
lien?
she was pretty upset with it because I had no reason why to have a lien against our house.
What about you? How did you feel?
Judge, I'll object to relevancy.
I guess, for purposes of the, I mean, to the extent it asks for an emotion, that's not really relevant, but I think he's getting at proving the factual predicate for the Consumer Protection Act counterclaim.
So yeah, you told us what Krista's response was. What was your response about learning about the construction lien?
Well, if I don't know anything about what it means, I had no response.
So once you learned about that, did you direct Krista in any way as to resolve it?
No.
So what do you believe is a fair resolution of this case against you, Deborah?
I had none.
Why is that?
Well, I never had any contact with anybody about anything that went on in the house, so why should I be responsible? Just because I'm a homeowner?
All right, so I don't have any other questions for you.
Any cross example?
Deborah, you gave Krista permission to call ServPro to have them come out and take the water from the basement in your home.
Yes.
Okay, those are all my questions. Thank you.
Okay, any redirect on, or
No, thank you, Your Honor.
go ahead and step down there. Mr. Kadan?
No other witnesses, Your Honor.
Oh, thank you. Mr. Slough, any rebuttal proofs?
None, Your Honor. Thank you.
Okay, do you want to take a recess before we take closings to gather thoughts, or are you ready to go?
I'm ready to go, Judge. I mean, I think
Okay.
we briefed this pretty thoroughly. I just want to hit the high points. And
Sure, go ahead
and
with
leave it to
closing.
you. So, Judge, this is a frustrating case because there's really no dispute. My client provided the services. They provide them in a good workman-like manner. And in fact, they were paid by the insurance company. And yet, for whatever reason, the Wileys refused to pay the deductible on their insurance and are leaving that on ServPro. And then on top of it, they're running up the costs by putting ServPro through this litigation. The Construction Lien Act, its primary purpose is to ensure payment to the contractor. Got a situation here where it's an emergency situation. You heard the Wileys testify to that. ServPro is responding to try to address this flood in the basement that's happening. There's no heat, there's no electricity to the home. And certainly there's issues with how this Construction Lien Act, or excuse me, this construction lien was filed. But again, the act only requires substantial compliance. And the reason for that is, again, the contractors are often being called out to respond, especially a contractor like ServPro. What it does is it responds to emergencies. So, there's got to be some flexibility there to effectuate the purpose of the act. The one exception to that is, of course, the 90-day deadline. That's what the case law says. I think that's the biggest issue here, is whether or not services, material, labor was provided within that 90-day period. And you heard the testimony that it was. In fact, ServPro provided a heating unit to the Wileys. Their furnace was not working. It was May in northern Michigan. It very well could have been cold, and they had animals in the house, so they needed some assistance. ServPro stepped up and went above and beyond and tried to help them out by giving them this heating unit.
Was that service connected to the service for which they didn't charge? Was that connected to the contracted services at all?
It was really not, in the sense that it had nothing to do really with cleaning the water in the basement. But it was a service that they provided because they were a contractor and they were there trying to help their customer. The fact it was connected in the sense that the furnace and the electricity were off in the home because of that water flooded in the basement. And so as they were finishing up the mitigation of the water, they recognized the customer had this additional problem. That happens all the time in construction jobs, where you dig in and realize that there's other issues that have to be addressed. And one of the issues they had to address was the fact that there's no heat.
Sure,
So,
but if your client's business consisted of, we provide temporary heating solutions in emergent situations, and they show up and put a monstrous electronic heater that can heat a 1,600 square foot home, they wouldn't be entitled to a construction lien for that service, right?
Oh, I think they would be. I think they would be, absolutely.
You think they would? You have a very expansive view of the Construction Lien Act.
Well, I do, because I think that the act has a very expansive definition of
What
improvement.
about somebody that goes and does carpet cleaning? Are they entitled to a construction lien?
Let me phrase it a different way, Judge. I think would put it in a better context. Someone who does HVAC work, that goes in and puts in a temporary furnace that provides heat, okay? That, no question, would fall under the Construction Lien Act. Okay, carpet cleaning. Look, if it's an improvement to the home, it falls under the act. Okay, I
bring in a piano tuner from time to time to tune my piano.
Well, it's not a fixture to the home. It would be personal property. So no, it wouldn't. But if it's a fixture to the home and it's an improvement and it increases the value of the home, absolutely, they're entitled to a mechanical lien. And I think the case law I cited even addresses that. And this goes back to the 90-day period as well. Even fairly nominal changes within that 90-day period count. So picking up equipment, cleaning up the job site, that is all service provided to the job, and would permit them to file a lien within that 90-day window, which was done.
Okay, thank you. Go ahead and continue. I don't mean to interrupt you. I like to
appreciate-
engage with some questions.
And I appreciate that, and I welcome it. The other big question here is Krista Wiley's role and Deborah Wiley's role. I think the testimony is crystal clear that Krista was acting as an agent for Deborah, who was the principal. And it's not a traditional agent-principal relationship, but it absolutely qualifies. The case law in Michigan, and I'm going to cite here from Chapa v. St. Mary's Hospital, it's 192 Mishap 29, 1991. The elements are the person dealing with the agent must do so with the belief in the agent's authority, and this belief must be a reasonable one. Well, again, Krista Wiley was there. She lived in the home. It's an emergency situation. No one had any reason to question that Krista had authority to authorize ServPro. And in fact, the testimony was that she did have authority, that her mom gave her permission to contact ServPro and get the water removed from the basement. The second element is that the belief must be generated by some act or negligence on the part of the principal sought to be charged. Well, again, Deborah Wiley testified she knew ServPro was being called. She saw ServPro's machinery there, equipment there, remediating this situation. So there was an act by Deborah Wiley in knowing that ServPro was coming, and the logical conclusion is that they're going to have to be paid for their services. And the third element is that the person relying on the agent's authority must not be guilty of some negligence. And again, under the circumstances with an emergency here, ServPro doesn't have time to do a title search to figure out who the proper owner of this property is. They've got an agent there who's saying that they have authority. The testimony is clear that they were given authority to make this arrangement. That apparent or ostensible authority under Michigan law binds the principal. So Deborah Wiley is bound to the acts of Krista, and ServPro can absolutely, under that agency theory, as well as really an unjust enrichment theory. I mean, Deborah received the benefit of ServPro's services to her home. So under both those theories, Deborah Wiley is personally liable, and her home is subject to that construction lien because her agent, Krista, signed the agreement that expressly provided a mechanical lien could be attached to the home. There's some argument in the trial brief Mr. Gadot filed about the lien only partially attaching to Krista's interest. Well, I've already addressed it again. Krista was acting as Deborah's agent. So Deborah was fully bound. But I just want to address the idea that somehow the lien only attaches to the item worked on. That's not how construction liens work. If someone puts in, again, a new furnace, you don't get to just foreclose on the furnace. You get to foreclose on the entire parcel of property that's improved by the addition of that furnace. So I just want to address that that's really a misconception of how these work. We don't get to just foreclose on the air that we dried. We get to foreclose on the premises that we improved by helping preserve and protect that property from mildew, rot, and enabling other contractors to get in there and fix the heat, fix the electric.
Well, there are lots of rentals in northern Michigan that aren't, we don't have a lot of apartment complexes. So a lot of rentals up north are residential properties. So, I know under the facts of this case, that the owner's living there and you've asserted some agency theories, but setting that aside, if there's an offsite landlord, by what authority is the tenant just contracting for things and now the landlord loses their interest in the property? How does that work?
Well, again, it's a different relationship. It's a different relationship because first of all, if ServPro shows up to an apartment building or in a place that, is obvious that it is a rental, then they have some responsibility to question, well, wait a second, do you have authority to be signing this? But you've got someone with the same last name who lives in the home. It's a residential home and is not at all questioning or saying, hey, I got to check with my mom. She's signing it. I mean, ServPro had no way of knowing that she wasn't fully authorized to do this. And again, I think the testimony establishes she was fully authorized. I think we're kind of past the apparent authority. She had actual authority. I mean, Deborah Wiley testified, I gave her permission to contact ServPro. I mean, she was her agent. I mean, that's established.
What about Krista's testimony that she told ServPro's representatives that she was not the homeowner?
I question whether that happened. I mean, I think some of Krista's testimony was dubious in the nature of her recollection. So I question whether that happened. Even if it did happen, okay, assuming Arguendo that maybe that did happen, it doesn't change the fact that she was in fact an agent for Deborah Wiley. Again, Deborah Wiley, crystal clear. I asked her one question on cross-exam. Did you authorize her to contact Servpro to remove the water from your basement? And she said yes. So it's an actual agency agreement between the two of them. The other question I would raise, Judge, is why didn't they file a cross-claim in the litigation if they were trying to hold Deborah harmless from Krista's actions? And again, I think it's because the reality is that she was acting as her agent. She did have authority to enter into this contract on her behalf.
So I understand how that plays into your construction lien claims. How does that play into your counts for breach of contract and account stated?
Sure.
Would
So
that, let's say that there was some deficiency, say the 90-day issue or something where the construction lien goes away, but you prevail on a contract theory. Who's liable under that contract? Only Krista? Or
no,
Deborah?
both Krista and Deborah. Because again, the agent can bind the principal, and the agent did bind the principal here. And again, under an unjust enrichment theory as well, because Deborah sat back and she watched Servpro do the work. She knew they were going to need to be compensated for doing this work. And I mean, I credit her testimony today, but in other words, I believe she was being truthful, but I mean, she was also clearly being negligent in the sense that she said, well, I didn't even read the lawsuit. I don't know. Krista was handling it. You know, I didn't really question how they were getting paid. I never talked to the insurance adjuster, you know, and that's fine. If she wants to take that approach, that's her right. But I mean, then she has to face the consequences of doing that, which is that she has her daughter authorized to do these things on her behalf, and then she's going to be bound to those things. The proper remedy would be she would then file a cross claim against Krista and say, hey, I never actually authorized you to do that. And that's how she would indemnify herself. But that didn't happen here.
Okay, go ahead and continue.
Thank you. The last couple items I want to address, we already talked about whether or not this qualifies as an improvement. I need to address the interest rate, or the finance charge is what it actually is. And I briefed this thoroughly. I'm going to rely on the brief for the most part, but defendant's counsel's brief talks about how under the Home Improvement Finance Act, this case isn't brought under that, and therefore that's not applicable. The point I raised in my brief was that a 1.5% finance charge monthly is authorized in another state statute for doing home improvements. So to say that 1.5% monthly as a finance charge is somehow usury, our own state legislature says that it's not. I mean, they've authorized it expressly for home improvement because it's a time price differential. It's not a straight loan of money at a particular interest rate. It's a time price differential in the sense that it costs Servpro money. And you heard them talk about that, the fact that, hey, when we don't get paid, we got to float payroll, we got to cover expenses and other overhead, and the price goes up. I mean, the price for them goes up in having to essentially unwillingly finance this bill for someone when they were expected to be paid in full at the time of completing the service. So that's the difference. And I know that, it can be a bit confusing, but that's how it works. Okay. And that's why they charge what they charge. That said, the testimony was also, they only charged it for a few months. They stopped once the lawsuit was being, wasn't even filed. I think it was before it was filed. Even it was in November of 2024, they stopped charging. So the total amount of interest, I believe, is around like $250 at 7%, the maximum allowed by law. If the court believes it's an interest rate, it would still be around $175 per year. So I think we're really talking about that amount of interest anyways. I mean, I think it would be a wash, and we would be still entitled to the max allowed by law under the terms of the contract. Do you have any questions about that issue, Judge?
Yeah, just the remedy, looking at the statute, would be if there was a usurious interest on the remedy, then the seller's not entitled to interest, and the buyer or borrower is entitled to attorney fees and court costs. What would be the situation if you were entitled to attorney fees under the contract, but the defendants were entitled to attorney fees under the usury statute?
Well, I
Is that
think
just a wash, or do we have to actually go through the bills and?
yeah, and I would have to look at the usury statute. I don't know that it entitles them to attorney fees under the usury statute. I think it entitles them to.
It does. I double checked that.
It's under the Michigan Consumer Protection Act that they.
No, under the usury statute. 438, section 32.
And again, our position is that it's not usury because it's not an interest charge, but if the court goes down that road, I guess you would then have to, analyze that about whether the court has discretion, whether or not to award those attorney fees under the circumstances. And then turning to attorney fees, we've asserted that the hourly rate at $300 is reasonable. I've submitted evidence of that's what I've charged for years. I anticipate filing a bill of costs if the court does award attorney fees, and laying all that out and giving counsel an opportunity to object.
Okay.
Do you have any other questions?
No, sir.
Okay. Thank you for your time.
Thank you, Mr. Slade. Mr. Kadat?
Thanks, Your Honor. What I want to do is I want to flesh out the legal arguments behind the claims in my opening statement a little bit. So we started off in our opening statement, Your Honor, saying that they can't foreclose on the construction lien and that the evidence will show minimal compliance, if compliance at all, with the statute. So the first thing was no improvement. So we have the, I attached 2 cases to my brief, Your Honor. One of them was the Northern Pipe case, and that's a Supreme Court case, and all the following will follow on the analysis laid out by that. Plaintiff's counsel accurately represents that case was about the 90-day deadline after completion of work or to file a lien. But the analysis was laid out for much more than that. The analysis was laid out to show us how the courts are supposed to regard any question of substantial compliance versus strict compliance. So as it comes to improvement, we have that, according to that Northern Pipe case, the analysis would tell us if substantial compliance were applied to that idea, the definition of improvement, would there be an absurd result or extreme prejudice or any type of prejudice? What we have is if a contractor or an alleged contractor only needed to substantially comply with the definition of an improvement, what we have is a situation where that becomes so broad as to allow just about anybody. And as the court pointed out, a carpet cleaner, I would point out a house cleaner, a snowplow driver. These are, to allow the plaintiff to get this court to judicially expand the definition of improvement to include actions like ServPro performed is so far, it just opens up the floodgates to things that are clearly not contemplated by the statute. So in my brief, I also cited a case that talked about an analysis for when you have a list in a statute, and then that analysis was to take the listed items as a class. And so that's another way to look at it. The class of examples provided in the statutory definition of improvement under the Construction Lien Act, Your Honor, is such that drying water is something that's much outside of the class of the same nature that cleaning a carpet or cleaning bathrooms or shoveling snow or plowing snow on the driveway. That's cleaning any of those things, but all of those things are outside of the class of examples. So, that's just fundamental number one. And without an improvement, they're not a contractor under statute. Without being a contractor under the statute, they can't foreclose on anything, but be it the lessee's interest or the owner's interest. Now let's get to that. So there is no contract with the owner. That's clear. They're arguing this agency relationship, but this is real property, Your Honor. I'm not aware of case law, just aside. I'm not aware of any case law that allows somebody to sign over the property of their mother without something more than apparent authority. There's got to be a power of attorney or something in place. And there was testimony that there was no power of attorney.
What about on the breach of contract claim?
The breach of contract claim, you know,
I mean, there's a clear breach of the contract
there is a clear breach of contract
by Krista.
by Krista, correct?
But what about the argument that Deborah is also liable for that because Krista was acting as Deborah's agent in signing that contract?
So it's not as strong from our perspective, admittedly, as it is regarding the real estate. But for a simple breach of contract or even an account stated, well, actually, I don't want to say that because that's different. So we have, if we just look, it's a slightly different analysis, Your Honor, because if we're just looking at the contract claim, we have clearly the contract is only signed by Krista. We have no reliance actually on the plaintiff's side to believe that Krista was acting as Deborah's agent. And this is evidenced by the bills that were only ever sent to Krista. They never attempted to bill Deborah. They didn't rope Deborah into this until they decided to move on the construction lien. So at no time can they prove that they actually believed until they came to file a construction lien that Krista was Deborah's agent, because they never demonstrated any reliance on that concept at any time. So, it is a slightly different analysis, but it would be invalid as, to show an agency relationship for those reasons, just on the breach of contract claim. Does that answer your question, or did
Yes.
I sidestep
Yeah,
it?
no,
Okay.
Continue.
Okay, so I'm going to resume back. Along the similar lines, the construction lien statute defines an owner and a lessee. As I pointed out in my brief, Your Honor, the lessee is what Krista is. The lessee is clearly defined under the act as somebody who is not the owner, essentially. I don't have the actual language in front of me, but there's no question that the act defines this relationship between Krista and Deborah, and that Krista is a lessee. If we're going to say that, it only requires that we substantially comply with the definitions of owner and lessee, again, that just reduces the whole statutory scheme to absurdity. In the plaintiff's brief, they mentioned that a co-lessee can bind a co-lessee, but they're not saying it for that proposition. They're saying that a lessee can bind or an owner because of it. It really makes no sense, Your Honor, where we have a statutory definition, and yet they're saying that the statutory definition doesn't apply to this case, essentially. And that cannot be any further from the truth. As to the lessee interest versus the owner interest, plaintiff in their argument a moment ago said something along the lines of, that's just not how construction liens work. They can't have a foreclosure on the improvement, but that's exactly what the statute requires. The statute says that if there is a contract with only the lessee, the only thing entitled to be foreclosed on or lien against is the improvement. So they can't argue in good faith that that's just that's not how construction liens work, because it does, because the statute says that's how it does. So then, the next issue, the next fundamental issue about this construction lien thing is that there was no lien filed within 90 days. So again, they're saying that we should take Well, I mean, any material supply, I mean, a fair reading of the statute would be that any material supplied or labor performed must be in the nature of the work that's being done. If they just left a piece of equipment behind that's not being used, not plugged in, it's just there because they don't have a need for it and haven't picked it up for a month, that's not of a nature of work being done or materials or labor being supplied. And as the court pointed out in his questioning of the plaintiff a moment ago, it wasn't even related, that piece of equipment, to the work that they were contracted for. There was so just going through the first three most basic requirements of a construction lien, Your Honor, they fail so dramatically that there is no arguable merit to the point where it's vexatious under the construction lien statute. As I noted in my brief, the standard for vexatiousness is found in the court rules for the Court of Appeals. Our appeals court has applied those standards because that's where they could find in the existing law vexatiousness and applied it to situations like ours. Because so these fundamental definitions aren't being met. There's no good argument for expanding the idea of substantial compliance when these things, when substantial compliance would just open a floodgates to absurdity if we do what the plaintiff wants. The ending of work a month after is similarly an absurd claim with no real arguable merit. And not to say arguable merit doesn't mean that no attorney will get up and say, X is Y and Y is Z, because that's making an argument. What we're talking about is arguable and a good faith standard that this is right under the law and this is what the law demands. And in this case, we just don't have that. We're not even close. And then we have the other requirement of the Construction Lien Act: no service of lien attempted within 15 days. They got the lien filed on August 5th. It's timestamped by the Register of Deeds. For us to believe that it took the Register of Deeds from August 5th until September 3rd to return that deed is another, it's calling for the court to just believe unreasonable things. It's just not it. Again, they're so far pushing the boundaries as to what these statutory scheme is there to do that it's alarming, and it needs to be severely sanctioned by the court in the form of vexatiousness finding and or a frivolity finding, because frivolity really is, along the same concept, no arguable legal merit. Still on the filing of service of the lien within 15 days of filing. They didn't even try. What we're talking about with the case law cited by plaintiff and attached to the brief and whatnot, we see substantial compliance is treated by the Court of Appeals and the Supreme Court to mean they tried something, they did something. It just wasn't exactly what was required. But here with this 15-day service of lien requirement, they didn't try anything. They didn't do anything that could be showing a step in the right direction. They didn't do anything for almost a full month, like 28 days after they should have. Similarly, there's no sworn statement prior to filing the case. I can see, there is a fairly persuasive appeals case attached to to the plaintiff's brief, Your Honor.
I mean, as to the 15 days, the record evidence we have today in the testimony is that the standard practice is as soon as they get it back, they send it out. And so that's what they did in this case. And, but that your clients didn't pick up the certified mail. So the plaintiffs say, yeah, we took an effort, meaning we send it out certified mail as soon as we get it. And to the extent that that wasn't strict compliance, it was substantial compliance, and your clients are not prejudiced thereby because they even refused to pick it up when we sent it to them.
So, well, there's a couple different things going on there with the court's comment. Let me address one. And so what we're talking about here is the substantial compliance with the 15-day requirement and the absurdity of plaintiff asking us to believe that, oh, we sent it out as soon as we got it on September 3rd. So that's a different ballgame than, hey, we sent it out as soon as we got it on September 3rd, and it's totally reasonable for us to have received it 28 days after filing it. You know, it's apples and oranges, Your Honor, insofar as the unbelievability factor has to be weighed very heavily here. The unbelievability that it took the Register of Deeds or the U.S. Postal Service 28 days to deliver a file deed. So I'm saying it's so unbelievable.
I have no unbelievability about the delay of the U.S. Postal Service. Since COVID, every attorney knows we used to rely on that a lot more than we really should rely on it now. I don't know why that is, why 5 years later it should be that way, but I can't tell you the number of cases I see where delayed mail delivery is a factor in the case. Happens all the time.
I don't know. So, you know, I'm fine moving on from that issue if the court wants to take that into account and weigh that more heavily than my arguments.
The sworn statement you were getting at.
Yeah.
So the purpose of the sworn statement is to let them know, like any other, who did the work,
right,
what work they did. And here, I mean, really, there's.
And we know who did the work, okay?
Right.
And we know.
So if that was the only deficiency.
If that was the only deficiency,
you probably wouldn't win and strike me down.
I would not run my flag up the flagpole just on that, but it's just an example of the gross delinquencies and the clarity of the statute, Your Honor, that says no case can be filed unless this is done prior to the filing of the case.
So fair enough. It's for illustrative purposes of their complete disregard of the statutory requirements.
Yes, that supports a finding by this court that their actions have no legal merit in this regarding the construction lien, imposition, as well as foreclosure, vexatiousness, as well as frivolity. So, as to that one issue, I'm sorry, I'm taking a lot longer than I thought I would.
Okay.
But as to that one issue, number one, we'd ask the court to void the lien and remove it, as well as the notice of attendance that's been filed. We'd ask the court to also, because the court would be justified in making a finding of frivolity and vexatiousness under the construction lien statute, my client is entitled to request reasonable attorney's fees, and under the court rules regarding frivolity, similarly. Okay, so we talked a little bit about the inability or just treating this as a breach of contract action. And I don't want to go too far into it, but as mentioned, when we took a tangent a moment ago, it was only Krista that signed the contract. The bringing an action against Deborah is frivolous because there's no contract with Deborah. So there's no, even, again, we have the difference between what an attorney feels like arguing, but what's actually arguable to determine what's frivolous. And even though the plaintiff's attorney can and did argue agency relationship, we don't have any reliance by plaintiff, no evidence presented that they relied on Krista as Deborah's agent for purposes of this breach of contract because the plaintiff never billed Deborah, never attempted to contact Deborah, never did anything with regard to Deborah. As to the issue of the account stated, that same logic applies, but it's even stronger because they never billed Deborah. For an account to be stated, there has to be a presentation of a bill at some level. And so it's absolutely lacking in arguable legal merit for them to claim that they have an account stated with Deborah when they never tried to bill her. That right there, I think, is our strongest argument for frivolity, Your Honor. Now, while we're still on the topics of these contracts, this contract, we want to talk about the Interest Rate Act. So we have shifting categorizations by ServPro as to what interest is. I believe in argument they said it was a charge, a finance charge, or a cost of credit, and then a time price differential. But here we have page 1 of Exhibit 3, where it says, let's see, 1, 2, 3, 4, in the 4th paragraph down, last sentence.
It's not a time price differential. It's a penalty interest for late payment.
Yes,
The way
okay.
because it doesn't say, hey, we did the service for you, take your time and when you want to pay it, and it's going to cost you this much per month to have that credit.
Yeah.
That's a time price differential.
Correct.
And this ain't that.
And this ain't that.
Okay.
Correct. Thank you.
I'm with you on that.
Okay, thank you. And so yeah, I guess I can move on from, well, I mean, just to be clear, because it's not a time price differential and it is a late payment penalty in interest.
So what should I do about that then?
Well, I think you have to do what the statute requires, Your Honor, and the statute requires no interest. Easy peasy. Statute requires attorney's fees. You know, I work for legal aid, in case the court or anybody here didn't know, we don't charge attorney's fees to our clients, but we have the ability to still collect attorney's fees, especially in egregious situations. And at any time up to trial, we could have negotiated away that claim. But here we are, and we've now spent, did they remove the clock from the room?
Yeah, we don't have a clock.
We've now spent,
It's noon.
3 hours, in addition to hours and hours and hours of preparation, when all of this could have been avoided if if it could have been made clear in plaintiff's opinion that they were barking up the wrong tree here. So even though we could have agreed at any point prior to today, probably, or even as of this morning, to not try to follow through on our statutory claim for attorney's fees under the Interest Rates Act, I think that ship has sailed, and I think we need to seriously push for that, because in addition to just the time expended by me and my clients, and we also have the greater public at large. If ServPro is doing this and this is their standard contract, how many people have ServPro already charged this usurious interest rate to? How many people will they continue to do so if they just get a slap on the wrist from this court and don't suffer from the extreme penalties that the law provides? We need to protect the public, and that brings us to the Consumer Protection Act claims as well, Your Honor. So the crucial language in the Consumer Protection Act statute is causing a probability. So we have to step in the shoes of each other or as a reasonable person. I don't believe that this has been fleshed out in the case law as to how do we.
But your claim under subsection O, causing a probability of confusion or of misunderstanding as to the terms or conditions of credit, if credit is extended in a transaction. That conflicts with, I mean, you're claiming under the interest rate
Right.
portion that this was not a credit extension.
Right.
So your subsection O claims, if you prevail on the interest rate act, would fail under the consumer protection, under subsection O.
Agreed.
Okay, continue.
So, sorry. Again, we're talking about the probability of confusion, but
As to the
confusion or
legal rights,
misunderstanding. And it's not, I'm
obligations,
sorry.
as to the legal rights, obligations, and remedies of a party, that seems to be
Correct.
perhaps your strongest claim under the
Thank you,
consumer
Your Honor.
protection.
So what we're looking at is probability. We're looking at preponderance of the evidence. What does the finder of fact believe is more likely than not as to whether there's a confusion or misunderstanding, or whether there could be the probability of confusion or misunderstanding? So here we have a contract that says they have to pay 1.5% per month interest. 1.5% sounds so little. Being a reasonable person, looking at this and thinking, wow, this is actually very low. It's de minimis insurance or interest. It's de minimis, finance charge, whatever it is, it's de minimis 1.5% per month. So no reasonable person is going to, do a full analysis on the spot as to what they're signing, if they do even read this contract, and learn that 1.5% per month times 12 months adds up to 18% per year. And that's far and above anything that could be considered de minimis. And it's far and above what the Interest Rate Act would allow. And so there's a high probability, much more than a preponderance of the evidence, that a person agreeing to 1.5% per month will be confused as to their legal rights, because this is not saying that it's usurious. It's on the surface not appearing to be usurious. Only with somebody who's willing to invest the time to do some, math multiplication in their mind or on paper, would a person see that, hey, this is high. And even then, they might not know that it's usurious and contrary to law if they have no basis, no legal education or understanding. So now, along those same lines, we also have a claim under the Consumer Protection Act that they charge grossly excess price by charging the usurious interest. And because they characterize this price, as a time price differential, the cost of extended credit, which I believe, is clearly not the case. This is the cost of their services built in, this 1.5% per month charge, which is grossly in excess to anything allowed by law. We also have the issue of the Consumer Protection Act's prohibition on entering into agreements without getting a clear waiver of rights, entering into agreements that waive rights without giving clear waivers. So a clear waiver of rights, Your Honor, would be not a sign here, an initial on the bottom of this page. It would be something of the nature that we just see in contracts from time to time of separately initial contracts. So for example, we have paragraph 9, page 2 of exhibit 3.
The jury trial waiver.
I'm sorry?
The jury trial waiver.
Yeah. So we have that, and that's in bold, but is that a clear waiver of rights? I think the strong argument is that it's not, because it's not asking for a separate initial or signature as to that paragraph. The only initial this page or signature this page asks for is an initial at the bottom for all of these terms. So that is not a clear waiver. Similarly, if there was going to be an argument that 1.5% per month was going to be agreed despite what the Interest Rate Act said, and it was going to be clearly waived if the Interest Rate Act or any other law allowed them to waive it. In order to get away with that, there would have to be a similarly clear waiver insofar as a separately initialed or signed paragraph relating to that term. So then we have the idea under the Consumer Protection Act as to ServPro misleading or deceiving the Wileys about a material fact, and the material fact, and that we've been arguing and testifying back and forth, one of many, and one of the more important ones is when did work stop? We have ServPro's belated efforts after sending their bills that end on April 29th or 30th and never sending another bill in the future for any work or labor or materials supplied after that date, leading the Wileys to believe that work was done on April 29th or 30th, the last time that they actually billed for something, and then saying, when they file a construction lien 4 months later, 3.5 months later, that, oh, by the way, we kept doing work or supplying materials or labor until May 30th. That is a clear deception, Your Honor, and there's no argument the plaintiff can make that will remedy that deception or explain it away. As the court so aptly pointed out in its questioning, whatever work ServPro alleges that they did from April 30th to May 30th wasn't work of a nature that they contracted for in the first place, and that could have arguably given rise to a construction lien if the other prerequisites, the definition of improvement, definition of owner, definition of lessee had been met under the act. So under the Consumer Protection Act, actual damages would be the $2,500 that they're being sued for. Attorney's fees would be, my attorney's fees. Both of those things can and should be ordered under that act for these violations. Alternatively, if the court didn't find that actual damages were warranted, the court has the ability to order $250 per violation that it may find of the Consumer Protection Act. So I think I touched all the issues that were raised today. So thank you, Your Honor.
Okay, thank you, Mr. Tiggio. Mr. Slavin, your rebuttal argument?
Yeah, thank you. Just briefly, Judge, starting with the interest. I guess what I'll start with is what I said before, that the state statute for home improvement financing, as I referenced in 17 of my trial brief, indicates a home improvement charge agreement may provide for, and the contractor or holder may then charge, collect, and receive a time price differential for the privilege of paying in installments under the agreement in an amount not to exceed 1.2% of the unpaid balance per month. So again,
right, but this wasn't an installment payment. This was your bill.
But it's essentially what the bill says, Judge, or the contract says, is that interest and finance charges will be charged at 1.5% per month on accounts 30 days past due.
Right, meaning this isn't all right, so now we did this improvement and you're gonna have an installment payment over a period of time. And for the privilege of that, it's this amount per month.
Right, but
this is very different, saying this is a bill, this is due upon receipt. And if you're late, we're going to charge you this interest.
Right.
How in the world is that a time price?
No, but it is, because when you read the language in the statute, what it talks about is, yes, of course, they actually state time price differential, but it's essentially the same thing. They're saying the privilege of paying in installments. Once it becomes 30 days
right,
past
but they
due,
weren't offered the privilege of paying in installments. They were given a bill saying it's due. And if you don't pay it on time, we're going to charge you interest. That's not the same thing as saying, here's the privilege of paying in installments, is it? I mean, one is where you arrange some installment.
I think that's the point. Maybe you disagree.
Well, then wouldn't every interest rate always be a time price differential?
No, No,
So
because
when
when
would
you borrow,
usury ever apply?
well, so to the most classic scenario, which is borrowing money, right? I mean, it's
Okay,
built
so
in.
only for that. Anytime it's a bill for services or goods,
I
the
think if you
usury
read,
statute just doesn't apply.
I didn't mean to interrupt you, I'm sorry. If you read pretty much any service contract, it has a finance charge provision built into it for this reason, because they can charge more for the service if they're forced to give the privilege of paying over time. Because again, the service provider wants to be paid in full upfront. And if it doesn't happen, essentially what's happening is they're being forced to take installment payments, whether it's one lump sum after it's past due or multiple payments over time or whatever. They're being put in a position where now they have to extend credit to that person involuntarily. And so that's why it's not usury. Okay, that's our position. The other thing I want to point out is that what the usury statute, in my reading of it, calls out is interest actually charged. The testimony was very clear. We charged interest or a finance charge between June and November of 2024, and then we stopped. And that amount charged was $233.60. If you were to take 7% interest from the date of delinquency, June of 2024 through today, it would be in excess of that number. It was like $237. So effectively, I mean, I understand the complaint that the defendants are making that, well, this could be a usury charge, but effectively it's moot because we didn't actually charge that much interest anyway. So it's not a violation of the usury statute. And maybe it's, we slid under the wire on this one, and I'm going to maybe have to talk to my client. If the court says that, no, this is not a legitimate finance charge, this is actually a hidden usury interest charge. But the reality is, in this particular case, they didn't charge that amount of interest. They charged only 4 months, and that would have been effectively 7% interest anyway. The last point on that is the usury statute does not say reasonable attorney fees. It does allow for attorney fees, but it says
his attorney fees. I do see that, yeah.
So
if there weren't any charge, there wouldn't be.
Correct.
I'm with you on that.
Okay, correct. All right. The next thing I want to address that was brought up is this idea of what I addressed in my brief as a lessee contracting for services. I was just quoting the statute, the construction lien statute, with regard to that argument. The other thing I said in my brief that I think is relevant in light of the testimony is that there would be testimony by Krista Wiley, I anticipated, that she was authorized to act on behalf of her mother, Deborah Wiley. And that's exactly the testimony we heard. So again, it's the agency relationship that we're really relying on.
Okay, because the lessee, 570.11073 cited by the defendants, does say that they provide an improvement to real property to which the person contracting for the improvement had no legal title. Then they have a construction lien upon the improvement for which they provided labor, material, or equipment.
Yeah,
and it does say that.
Yeah, yeah, and again, I think
so. Then shouldn't your client, like I said, lots of rentals in northern Michigan are houses that sit on land. They're not apartment complexes. And he testified, well, I had no reason to think she wasn't the owner, but my goodness, he'd be at risk of all sorts of providing services to all sorts of situations where it's the tenant.
Yeah, it would in that scenario only be to the extent of the lessee's holder's interest, which may be, and I think what the statute's getting at there is like in a commercial context, a commercial fixture is separable from the real property. So you may have a leaseholder who puts in a lift in the garage.
I understand, but what if it's not separable? I think you don't get at the lessor's interest in property under that statute, do you?
Well, again, I think that I don't know we even need to answer that question.
Because of the agency.
Because of the agency, correct. So before going through the hypothetical there, I think that the reality is that we have the agency here, so it doesn't even apply. All right. Moving next to substantial compliance. The sworn statement.
I'm not worried about the sworn statement.
Okay. I won't even go there. The mailing the lien. Same thing. There's a good faith effort there. And I will just say, I'm just incidentally, as an attorney that does many deeds and sends them to registers all over northern Michigan, it's anywhere from 3 days to 30, depending on, what the workload of the register is. Okay. So the improvement. Okay. What I want to point out here is the language of the statute includes something that wasn't really emphasized in Mr. Dodd's brief. And that is, this is MCL 570.1104, number 6, where it defines improvement. The result of labor or material provided by a contractor, subcontractor, supplier, or laborer, including but not limited to, and I emphasized that before, so it's not exclusive to this list. And it talks about surveying, engineering, architectural planning, clearing, demolishing, excavating, filling, building, erecting, constructing, altering, repairing, ornamenting, landscaping, paving, and then this is the one I want to emphasize, leasing equipment and installing or applying a fixture or material pursuant to a contract. There was plenty of testimony that ServPro did essentially do that. I mean, they're bringing equipment onto the property to allow the homeowner to utilize it to address a problem on the property, which is to dry up the basement, the humidifiers, the heaters, okay? And again, you asked me before, you're taking a very broad reading of the definition of improvement under the Act. This is why, because the Act really is really broad about how it defines improvement. And I think even if you limit it just to that list, there's arguably things ServPro did that fit within that list. The last thing was, it was mentioned by council that we never billed Deborah Wiley for these services. I mean, look, the fact is, not only do we already talk about the agency and her being well aware ServPro was doing the work, we did send her a bill in September of 2024. It's marked as an exhibit and the court can see it. The reliance we had was that we did the work. You know, the reliance is that we did the work expecting to be paid. And to say that we didn't somehow rely on the fact that we were going to get paid is incorrect. So we would ask the court to enter a judgment jointly and severally against both Krista and Deborah Wiley for the full amount owed and permit us to foreclose the construction lien according to law.
All right, thank you.
Thank you.
Well, I did have an opportunity to review the exhibits as they were being testified to, and also on some of the breaks, or not breaks, but the pauses while the attorneys were talking. I did have opportunity to scan through Exhibit 1, the deposition testimony of the insurance adjuster, and saw her testimony about that Deborah Wiley is the homeowner and the insured, but that she was dealing with Krista Wiley for purposes of the claim, which evidence is offered to bolster the plaintiff's theory for agency. So I did have an opportunity to review the evidence, and I'm prepared to make my findings at this time. There's really no factual question here about the work that was done. So at its simplest, ServPro did some work for which they are entitled to be paid. And that includes and they were paid by the insurer, but then there's this deductible amount, and they're owed that, and they're entitled to collect that. So that's not really what this case is about, but this case is about how are they entitled to enforce that obligation. And they filed a suit alleging 3 counts: breach of contract, account stated, and foreclosure of a construction lien. So here, factually, the work that was done, testified to principally by Mr. Bailey and documented through the exhibits, was there's water in this Michigan basement, and they showed up with specialized equipment they had and wore protective gear to extract the water with a submersible pump, and then through some trucks and hoses to extract the water, pull out some debris, set up some drying equipment, air blowers, dryers, and sprayed some antimicrobial to make sure that, there's no unintended funk down there, I suppose, afterwards. And so there's no dispute about the nature of the work that was done. The question is the legal effect of that work and whether it makes ServPro a contractor under the Michigan Construction Lien Act, and whether they complied with the terms of that act in asserting a construction lien. So I guess I'm going to address count 3 of the complaint first: foreclosure of the construction lien. And on count 3, I'm going to enter a judgment of no cause of action on count 3 and rule for the defendants. on the foreclosure of the construction lien for two principal reasons. One, the court is not persuaded that ServPro is a contractor that provided an improvement under that statute. The definition of improvement is set forth at 570.11047, means the result of labor or material provided by a contractor, subcontractor, supplier, or laborer, including but not limited to surveying, engineering, and architectural planning, construction management, clearing, demolishing, excavating, filling, building, erecting, constructing, altering, repairing, ornamenting, landscaping, paving, leasing equipment, or installing or affixing a fixture or material pursuant to a contract. They had a contract to provide some services, but those services, although they may be specialized, they're the nature of just, extracting some water and drying it out. That is not the kinds of, when we look at this list of labor and material, these are construction related matters. And if the plaintiff's theory were true, then just somebody that came in and performed carpet cleaning would be entitled to a construction lien to foreclose on the home. And I just don't think the Construction Lien Act is that broad. The services here, I don't mean to demean or diminish the efficacy or the necessity of them, or even the emergent nature under which they were provided. But they're really just, it's a difference of degree, but not kind of, cleaning up something that has happened in a home that's a mess. So I just don't think that that's the kind of service for which homeowners are subject to losing their property by a construction lien. Whereas if they're having physical improvements done to the home or the property, like construction, landscaping, things of this nature, then they're on notice that, they're doing stuff to construct or make improvements to my home. So my home is on the line. But here, just to extract some water and dry it out, I don't think that's an improvement. But even if it were, I think the evidence clearly showed that the lien was not filed within 90 days of the last date of services. The testimony of Mr. Bailey was that the last day of the water extraction and drying services was in fact April 30th. The lien was filed, was recorded on August 5th, which would be outside that 90-day window. The plaintiffs rely upon the last day of labor and material being May 30th, because that's when they removed a electrical heater that they had left there. But what's important to note is that they didn't leave it there to continue to provide the services that they were contracted for. A, they didn't charge for it. B, it wasn't in the basement or anywhere that needed further drying. And C, by Mr. Bailey's own testimony, he did that really sort of out of kindness because there were animals at the property. I mean, even crediting him that this was in use and over Miss Krista Wiley's testimony that it was there but not being used, even assuming it was used the whole time. It was for the purpose of keeping the animals warm in a house that was unheated. And he didn't charge for that. That's not connected at all to the services that were provided. And the case cited by plaintiffs, the 1980 case, Bullheist Lumber, that talked about, that was attached to their brief, and that talked about, even after the contract is substantially completed, claimant does further work or furnishes further material, which is necessary for the proper performance of his contract and done in good faith. So here, there was still a heater left and it was used, but it wasn't necessary for the proper performance of the contract. The proper performance of the contract was clearly done on April 30th, not May 30th. So the fact that Mr. Bailey volunteered to leave a heater there to help out the animals doesn't change the nature of that contract or extend the terms, extend the date under which services or materials were provided pursuant to that contract. So even if ServPro is a contractor that provided an improvement, they did not timely record the construction lien. So the court would find for the defendants on count 3 of the complaint. But that does leave counts 1 and 2, breach of contract and account stated. Here there was, I think clearly Krista Wiley has breached a contract to pay the $2,500 of the insurance deductible because she signed the contract with ServPro to provide the services and to pay the amount that was due. Has Deborah Wiley breached that contract? I think the answer to that would be no. She didn't sign the contract. There was some evidence that Krista does a lot of things on behalf of her mom, and they both live there, including Krista was the one that communicated with the insurance agent. Krista was the one that reached out, contracted with these folks, but they didn't seek to secure the signature of the homeowner. There was testimony that Mr. Bailey went out there and said, it never occurred to me that someone else owned the property. Well, he didn't do any due diligence to discern that. There's tons of rentals that they're homes that are being rented. And just contracting with the tenant isn't going to obligate the landlord. And here, even with the landlord residing there and being related, I don't think that changes. And in fact, Krista Wiley testified that she told ServPro's representatives that she was not the homeowner. That testimony's been uncontroverted. There's just nothing that Deborah Wiley has done to obligate herself to this contract. We also have the question about what the plaintiffs are entitled to under that contract. The contract does allow for the recovery of attorney fees, and also it includes this 1.5% per month interest or finance charge. The court is persuaded that on these facts that contract violates the interest rate statute, MCL 438.31, because it charges interest beyond the amount authorized by statute, and there would be in a contract of usury. The plaintiffs assert that this is a time price differential for the extension of credit. That's not the case. This is quite clearly a bill that is due when it is sent, and they want it paid in full. And if you don't pay it in full, we're going to charge you interest as a penalty on the delinquency. And Michigan's usury statute places limits on what that would be, far below the 1.5% per month. It's not saying pay this as long as you want to pay it, and it's going to cost 1.5 per month for that credit. This isn't that at all. It's an interest on a delinquent bill, and it is usurious. So under the statute 438 section or 438.32, any seller or lender or his assigns who enters into any contract or agreement which doesn't comply with the provisions of this act or charges interest in extent of that allowed by this act. So even the plaintiff argues, well, the interest we actually charged wasn't all that much more than what would have been allowed, but the language of the statute says when you enter into a contract, that's violation. And then the plaintiff then is barred from the recovery of any interest or any official fees, delinquency or collection charge, attorney fees, or court costs. So therefore, the court would find that due to the usury, on count one, the breach of contract, the court would enter judgment in favor of plaintiff against defendant Krista Wiley only in the amount of $2,500 and bar costs, fees, and interests under 438.32. The court would enter a judgment for Deborah Wiley on count one, the breach of contract, because she isn't obligated under that contract. Defendants claim that they should be entitled to recover reasonable attorney fees because of the usury. But the statute talks about recovering his attorney fees and court costs. So the statute is worded in terms of actual fees, not reasonable fees. And Mr. Cadat, working through legal aid, does not charge the defendants here. So the defendants have incurred no actual attorney fees to recover. So that claim would be denied. And then count 2, the account stated the court would enter a judgment of no cause of action and rule for the defendants in that. The court's not going to enter judgment on an account stated that includes the usurious interest. So on the complaint, count 3 and count 2, judgment for defendants. Count 1, judgment for plaintiffs against Crystal Wiley only in the amount of $2,500, not allow costs, fees, or interest. Of course, once the judgment is entered, judgment interest would apply, but there would be no interest under the contract. And then we have the counterclaim was Miss Deborah was complaint for quiet title, extinguishing the lien. The court would find in favor of defendant Deborah Wiley on count 1, quiet title, for all the reasons that the court denied the construction lien foreclosure. And count 2, the Michigan Consumer Protection Act. I don't believe that this contract, as I reviewed it, does anything that would intentionally or by design or even be reasonably expected to result in any confusion or unfair practices. The fact that it refers to an out-of-date statute, the Mechanics Lien Act, the fact that it includes some waivers of rights, but they're in bold, and that page is initialed. Even the fact that it charges interest that the court later determines should not be charged. None of those things would rise to the level of a violation of the Michigan Consumer Protection Act. I don't find that the plaintiff has engaged in any unfair practices under that act and would enter judgment of no cause of action in favor of the plaintiffs then on defendant's counterclaim of count 2. So I believe that that covers all of the claims and counterclaims. I guess I'll sort it out between Mr. Cadat and Mr. Slough because it's a mixed bag who will prepare a judgment. Okay, thank you. And do I understand that defendants A is equipment that would be owned by your clients?
That's what I understand.
Would you receive defendants A?
I will take exhibit A.
Any objection to that, Mr. Cadat?
No, thank you, Your Honor.
Okay.
May I ask one clarifying?
Yeah, go ahead.
So we had raised defenses of vexatiousness and frivolity. Is the court able to make a ruling on those issues?
I'm not finding that the claims asserted by the plaintiff were vexatious or frivolous. They do provide services to homes. I think we probably still are even disagreeing with this court's ruling on that, and I don't think that their position was so unreasonable or outside the bounds of that statute or law as to be vexatious or frivolous.
Thank you, Your Honor.
Okay, thank you very much.
Thank you.
All right.